Hi, everyone.
Chair, just letting you know I'm starting the live stream.
All right. Good evening, everyone. At this time, I'd like to call this meeting to order and welcome you to the Rent Stabilization Commission meeting on Thursday, June 24th, 2021. Please, everyone, follow me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all. Mrs. Secretary, may we have a roll call, please?
Commissioner Copeland,
Here.
Commissioner Harris,
Here.
Commissioner Maggio,
Present.
Commissioner Martz is absent tonight. Commissioner Montemayor,
Here.
Vice Chair Kirby's,
Here.
Chair Topshin.
Here. We have a quorum. Thank you very much. And approval of agenda is our next item.
I'll make a motion to approve the agenda as posted.
I'll second.
We have a motion to approve the agenda and also a second. Mr. Secretary, can we have a roll call?
Commissioner Copeland,
Aye.
Commissioner Harris,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz, sorry, is absent tonight. Commissioner Montemayor.
Aye.
Vice Chair Kirby's,
Aye.
Chair Topshin.
Aye. Agenda is approved. Next is approval of our minutes. Has everyone had a chance to review the minutes of our last meeting from June 10th, 2021? And I know, Mr. Secretary, you mentioned that we need to amend the minutes to include to acknowledgement that the legal counsel, Joan Natalia, was also present at the meeting, correct?
Correct.
Okay, so with that amendment to the minutes, do we have a motion?
I'll move that we we approve the minutes of June 10th, 2021 with the amendments.
Second.
Thank you, commissioners. We have a motion and we have a second. Can we have a roll call?
Commissioner Copeland,
Aye.
Commissioner Harris,
Aye.
Commissioner Maggio,
Aye.
Commissioner Montemayor,
Aye.
Vice Chair Kirby's,
Aye.
Chair Topshin.
Aye. Motion carries and minutes are approved. Thank you very much. Next is public comments. Mr. Secretary, do we have a speaker? Do we have speakers at this time?
We have 3 speakers. I'll bring in Jillian Marcus first.
Okay. And before the speakers will be allowed to address the commission, I'd like to state that the Rent Stabilization Commission values your comments However, pursuant to the Brown Act, the commission cannot act on items not listed on the posted agenda. Members of the public have 3 minutes to speak. This public comment period is to address the Rent Stabilization Commission on agenda items or items of general interest within the jurisdiction of the commission. An additional public comment period is available at the end of the meeting. With that said, who is the first speaker?
We have Jillian Marcus. Jillian, if you could press *6 and unmute yourself.
Okay. Please first state your name and city of residence, and you will have 3 minutes to speak.
Looks like she's still on mute. Jillian, if you can press *6 and unmute yourself. I'll ask her to unmute again.
I'm going to do it through the computer because on the phone, it's still saying I'm muted.
Oh, we hear you. We hear you
Okay.
now.
Okay. Ms. Marcus, yeah, can you state your name for the record and city of residence, and you will have 3 minutes to speak.
Sure. My name's Jillian Marcus. I live at 8736 Rangeley Avenue.
Thank you. You may begin.
I've lived at 8736 Rangeley Avenue for over 20 years. The building was sold this last January 2021. I contacted my previous landlords approximately 20 times in both emails, texts, and the tenant portal that there was a pipe leaking under my sink, which continued to leak. And the pipe was fixed eventually in February 2021 by my new landlord's plumber. After that, at the end of February 2021, I noticed there was mold on the kitchen wall by the pipes. I do not know what caused it. I am aware that the tenant has a duty to inform the landlord about a hazardous condition, and I did inform both landlords over 20 times about the leaky pipe. I let the new landlords know immediately that there was mold, and when they did not respond to fix it, I contacted the Los Angeles County Department of Public Health to open a complaint. The landlord subsequently sent me several threatening, harassing, and bullying emails that it was my responsibility, even after the Los Angeles County Department of Public Health contacted the landlords and informed them that it is the landlord's responsibility to make the repair. My current landlords are telling me that I am responsible for the water damage and mold, which they believe incurred as a result, and are threatening to force me to pay for the repair. The landlords have pointed to a clause in my original lease that I signed in the year 2000 that states any drain-lined maintenance will be the renter's expense. After I contacted the Los Angeles County Department of Public Health in February, the landlords did not respond to the county's request to fix the mold until 4 months later, after the Los Angeles County Department of Public Health came out a few times. The landlord sent me several threatening emails, and they eventually sent me an email that they're going to bill me for the repairs. The problem was long known to the landlord because I've contacted the landlord many times about it. The Department of Public Health could not offer legal advice on the lease clause. The manager knows or should know that maintaining the plumbing is the responsibility of the landlord. Health and Safety Code 17920.3 says that all plumbing, except plumbing that conformed with all applicable laws in effect at the time of the installation, has been maintained in good condition, should be in safe, good working condition and working properly. The landlord told me that I must offer explanation or evidence to absolve myself of the financial responsibility, since the landlord has to make the repairs despite my having reported the leaking pipe as much as 20 times. The landlord has vengefully told me by email that he
That is your time.
Okay.
Thank you, Ms. Marcus. Next speaker, Mr. Secretary, please.
Yes, I am bringing in Elena Argentini.
Okay.
Elena, if you could press *6 and unmute yourself. Hi, Elena, if you can hear me. Oh, there you go.
Yes, I'm here.
Okay, ma'am, Miss Argentini, good evening. Can you please, you will have 3 minutes to speak, but before you begin, please state your name and the city of residence for the record, and you may begin.
Okay. My name is Elena Argentini, and I live in West Hollywood. Hello, members of the Rent Stabilization Commission. As I said, my name is Elena Argentini, and I've lived here for over 28 years. I'm in a 12-unit apartment complex on North Vista facing Ellis Act eviction on October 1st, as soon as the moratorium ends. I would like to first quickly thank the Rent Stabilization team for, one, existing, and two, for being helpful and supportive as we're facing this truly difficult situation. I'm speaking on a couple of issues that directly affect me and my fellow tenants currently. The first is relocation fees. We're grateful that there are relocation fees and that there are yearly adjustments to these fees. There are a few factors, though, that we're asking the Commission if you would be willing to consider when evaluating possible increases. The first is longevity of tenancy, market differential of rent, and possibly a pandemic bump due to the particularly difficult challenges tenants are facing this year. To be honest, as we're facing the eviction into the current housing market, the current fee amounts feel very low, especially as they're taxed, which we know you can't do anything about. If the fees were a little bit higher, it would definitely help us and increase the possibility that we could possibly stay in West Hollywood. The other issue is tenants in common. Our buildings are slated to be converted to tenants in common. And the ease with which we're being displaced is truly shocking. It seems not much more is required by the new owner than a completed form and the $2,200 filing fee. Our new owners have already bought 3 buildings in West Hollywood since the pandemic and looking to buy more. We're here to sound the alarm that TICs without more restrictions in place are going to flood our streets and get the soul of the city. With condos, there are restrictions that in many instances are prohibitive and make no-fault evictions challenging or impossible. The few things that we were hoping you would look at would be 1 year for no-fault evictions instead of 120 days. Living here 28 plus years and being given 120 days to exit feels harsh, especially when one looks at the practical challenges of packing decades of belonging and looking to find a new home when facing rents that are at minimum double what we're currently paying. Additionally, if the minimum was raised to 1 year, for example, it might incentivize the new owners to offer more realistic buyouts, since 120 days is so short that they can simply wait us out. The other is the right of first refusal to possibly purchase one of the TICs, and then also to require or incentivize new owners to earmark one or some of the units to fall within affordable housing guidelines. There's many other restrictions that could possibly be imposed on TICs, but those were just a couple that we are realizing would practically impact us. We really appreciate the opportunity to speak and know that I speak for myself and the fellow tenants that we love living in West Hollywood. And we've stayed here not just because our rent is cheap, but because I love our homes and our city, and we really are trying desperately to stay living here. Thank you so much. Bye.
Thank you. Thank you, Ms. Argentini.
You're welcome.
Next speaker, Mr. Secretary.
Yes, we have Aaron Kasu.
Aaron Kasu, okay.
Many other restrictions that could possibly be imposed on TICs.
Sorry, let me bring him back in.
Okay.
Looks like we may have lost him. Let me.
Sure.
Sorry, Chair. Yeah, it looks like we lost Aaron.
Okay, if the speaker comes back, they can speak at the end of the meeting, and we can move forward. Mr. Secretary, do you hear?
Yes.
Okay, all right. With that, so move forward to the next item, which is the manager's report, and Mr. Acting Manager, Mr. Hollop is here, and this is your time, sir.
Thank you, Chair. Good evening, Chair, Vice Chair, Commissioners. Jonathan Hollop, Acting Manager of the Rent Stabilization and Housing Division. quickly going to look ahead. We've got one appeal this evening, and after that, we're going to be presenting the commission with its announcement of the annual general adjustment and the increase to relocation fees. July 8th, there's another appeal for the commission to hear. At that time, you'll also be electing a chair and vice chair. And you will likely be hearing a report from the ad hoc committee on valuation guidelines. On the 22nd, there's another appeal for the commission. At that time as well, staff will be presenting a housing element update for the commission. There may be some regulation amendments coming at that time, although I might be moving those to a later date, but I'll have an update for you at the next meeting. And then we've got appeals scheduled for the commission all the way at this point through September 23rd. Aside from the look ahead calendar, I wanted to talk a little bit about the recent developments with the eviction moratorium. At its June 21st meeting, the city council directed the city manager to extend the eviction moratorium to September 30th if the state and county did not take action to extend the existing eviction moratoria before June 30th. On the 22nd of June, the county extended its moratorium, which will cover West Hollywood tenants beginning July 1st. We're still waiting to see if the state will act to extend its moratorium for evictions for non-payment of rent due to COVID-19 related reasons. It's my understanding that there will be hearings on this in the legislature on Monday, and obviously we would expect action prior to the expiration of the moratorium on June 30th. Since the county did enact a extension to the moratorium, I'm going to go through some of the broader points on how that will impact West Hollywood. Hopefully you can see this. Let me get the full screen. Okay. Roger, can you see that?
Yes.
Thank you. Okay. These are the county eviction moratorium protections. As I mentioned, it will apply to West Hollywood tenants effective July 1st. There will be no evictions for non-payment of rent due to COVID-19 financial impacts, so long as the tenant gives the landlord notice within 7 days after the rent comes due. And this will only apply if the state doesn't extend its moratorium. The state, as you know, West Hollywood, the county, other jurisdictions did have a moratorium of this type, and then the state enacted its own law, which preempted the local provisions on this subject. So if the state goes ahead and extends its moratorium, which it is being worked on, and the information I'm receiving is that the talk is to also extend that to the 30th of September, then that would apply, and the form remains to be seen, but it could continue to be what is currently in place, which is 15-day notice from the landlord, which triggers a declaration from the tenant to then also pay 25% of the rent. Regardless of what the state does with its extension, so long as the county moratorium is in place and is covering West Hollywood tenants, no fault evictions continue to be prohibited. There is a small carve out in the county ordinance for owner occupancy of single family homes in certain limited circumstances. If there are any tenants, and there likely wouldn't be that many who would face this type of eviction in West Hollywood, but they can contact, they are landlords who are qualified or think they might be qualified, can contact the division. But like I said, there are restrictions on even when this can be done during the moratorium period. No evictions are permitted for nuisance or for unauthorized occupants or pets whose presence is necessary or related to the COVID-19 emergency. Evictions are prohibited for denial of entry with some exceptions, such as, not surprisingly, remedying repairs of dangerous conditions. And those are the highlights. And this will, as I mentioned, be in effect through September 30th, 2021. And that is, I think all I have. Oh, I also wanted to mention one more thing. There is still funding available for under the California COVID-19 rent relief program. Anyone that includes tenants and landlords should visit housingiskey.com. It's an excellent website. It gives very detailed information about qualifications for the program for both landlords and tenants, and guides them to the application. And that is also another item that I believe the legislature is taking up to streamline that process and hopefully allow more folks to be captured into that program. So more to come, I'm sure, in the next week, and more to report at the next meeting. And I'm available for any questions.
Commissioners, are there any questions to Mr. Manager? I have one. That's regarding the eviction. I want to understand. So the eviction moratorium is based on what the county moratorium is right now in West Hollywood, or the city offers any additional layers of protection or anything? Right
now, the city moratorium is still in effect through June 30th. As of June 30th, that expires. But because the county ordinance also covers incorporated jurisdictions, West Hollywood will be covered by that. At this time, the direction is to maintain the coverage under the county ordinance. And what the city can or cannot do in the future may be dictated by statewide action. But at this time, the broader moratoria will remain in effect. And when I say the broader ones, I mean protection from eviction for non-payment due to COVID-related reasons and no-fault evictions will remain in effect after the 30th for West Hollywood tenants. Okay. Yeah, the reason why I'm asking is because in your report, you said that it was very interesting because one of the speakers had a question about the 1 year no-fault eviction extension to 1 year no-fault eviction. I wonder if any other jurisdiction have a 1 year moratorium on no-fault evictions, if you're aware. No, not that I'm aware of. I think possibly the context of the comment may have related to Ellis eviction, since I think that there was a mention of the 120-day notice period, and that is, taking the moratorium issue aside, that's governed actually by state law. Right, but the Alice eviction moratorium is not included in the county moratorium. Maybe I missed that. There's a moratorium on that as well. So there is a moratorium. That's a no-fault eviction. Yes. Okay. All right. Okay. Cool. At least after June 30th, the residents in West Hollywood have additional protections from evictions. So that's a good news. That's a good news. Thank you, sir. Commissioners, any other questions, comments at this time? All right, then. Thank you, Mr. Manager. And we'll move on to the commissioner's comments. Commissioner Maggio, please.
I just have a small comment here. I know that when individuals come before us under public comments, that we are not required and will not answer their questions or try to solve their problems. But I think we should at least direct them in some way, direct them to the staff or where they need to go in order to answer some of the questions that are so important to them, instead of just leaving them hanging. Thank you.
Thank you, Commissioner. Commissioners, Commissioner Ayers, anything?
Yeah, I just want to echo Commissioner Maggio's comments. I believe that, I thank our speakers for coming forward. Even though this commission can't address the specific issues that are brought before us in public comments, it's good for us to hear what's going on in the city and for us to be made aware of those things and have the opportunity to encourage our city staff to reach out to those people and see if there are resources that can help them so they can, follow the procedural chain that the city has set up for them to at least, be aware of what resources we have and maximize the use of them.
Great. Thank you, Commissioner. Commissioner Copeland.
I will echo their comments as well. I was thinking that as I was listening to the comments that we're not able to take any action, but certainly it would be nice for someone to point them in the direction that they may get some help. If there's a way to do that, I echo my fellow commissioners' feelings on that one.
Thank you. Commissioner Montemayor, anything at the same?
No comments at this time. Thank you.
Thank you. Vice Chair?
Yes, thank you. I also wanted to thank the speakers tonight and thank them for their participation and letting us know. I also wanted to follow up on the director's report. The bill that, if the legislature is able to pass it, that would extend the eviction moratorium beyond June 30th for the state to follow will be AB 832. It's not, the text isn't in there right now. It's about a different issue, but that will be changed, I believe, tomorrow and probably be printed on Monday as they begin debates on that issue. So follow AB 832 for the latest on
AB 832. Okay. Thank you, Vice Chair. All right. And I just want to briefly also mention, and I agree with the fellow commissioners regarding the public speakers. As Commissioner Maggio mentioned correctly, so we cannot go into a discussion on the issues with the public, but I would definitely encourage the public to attend our meetings and to address their concerns, make comments, and don't think that this is not going to be heard. Staff is watching and we're taking notes. And I really appreciate and thank the members of the public who spoke tonight. And I will encourage them to come back and to report on what's going on and to share with us your thoughts and your ideas, your concerns. It's very important. On that note, I was actually going to ask if staff could look into the what was said by the first comments by the first speaker. I didn't catch the address, and I'm not sure if that's a rent stabilized property or not. If we, I'm pretty sure we have a recording and we can get the address. And if staff could look into that, what's going on in the building, whether it's an isolated issue with with one tenant, or it's a building-wise issue, and if it's a rent stabilized property, so what can we do? Maybe we can outreach to the tenants, and maybe we can provide information. If there are ongoing problems, then maybe the tenants can, contact the department, file complaints. Maybe we can send the inspectors out. I believe the tenant also mentioned something had to do with also Ellising the property, or what's going on there. So if staff could just look into that, and it would be great to hear from staff the next meeting. That basically will be my comment at this time. Commissioner Maggio.
Yes, I wanted to comment on the street Rugby. It's a street that only exists in West Hollywood between Doheny Drive and San Vicente. So it is a street that exists only in West Hollywood.
Yeah, I didn't catch the address or the street name, so that's why I cannot really comment whether it's a rent control property or not. So it could be a newer construction, so we don't know. But thank you for the comment, sir. All right, if no other comments, commissioners, we'll move on to the appeal portion of the agenda tonight. And we have one appeal scheduled tonight. And it's application D-4567 before us that pertains to the property address 1216 North Crescent Heights Boulevard, unit number 16. And it has to do with a reduction in rent due to the loss of housing services. This appeal was filed by both landlord and the tenant. And I see that both parties are present, and I believe, I hope there are no connection issues. So before we begin, I will take a moment to provide some information on the instructions on the appeal tonight. First, the commission will hear the staff report presented by the legal counsel, Mr. John Natalia. After that, the commission will have the opportunity to address questions to the legal counsel, and then I will open the oral argument portion of the appeal, where the parties can present their position and present their case. Since the landlord filed the appeal first, and that's confirmed by the department, the landlord will speak first, and then the tenant will speak next. Since both parties filed the appeal, so both parties will have a total of 5 minutes to address the commission, to present their case. So you may divide your time between the presentation part of your testimony and the rebuttal portion. So it's up to you, or you can take the 5 minute total entirely at one time.
Can I clarify something?
No, you can't speak at this time. So then when the time is to speak for you, you will state your name and the city of residence for the record. You will indicate if you'd like to divide your 5 minute segment, and then you can proceed with your comments. Since your time is limited, so it is very important to keep in mind that you should keep your comments on topic. You can only provide the information that was presented in the appeal hearing. The new evidence cannot be presented. So the commission cannot review any new evidence. After that, when the oral argument is closed, the commission will begin their deliberation. And by the way, the commission may ask you questions after you speak, after you present your case. So with that said, I will, this is your time, Mr. Natalia, you can present your report.
Good evening, Chair, Vice Chair, and Commissioners. This is John Natalia. I'm the legal counsel to the Rent Stabilization Commission for the city. An appeal was filed by both tenant and landlord. Tenant is William Horn, who resides at 1216 North Crescent Heights Boulevard, Unit 16. Landlord is Crescent Hills Loft LLC, as represented by Steve Short. Tenant filed an application seeking a rent reduction for lost housing services related to the collection of rent, access to rooftop decks for recreational purposes, interior painting, and the overgrown condition of outdoor plants that were diminishing his unit's natural light. The hearing examiner granted a $57 rent reduction for the issues relating to rent, which was $7, and interior painting, which was $50, and denied a rent reduction for access to the rooftop and the diminishment of natural light. Tenant appeals a decision claiming that it is clearly an error, is not reasonably supported by the findings made or evidence in the record, constitutes an abuse of discretion, and is contrary to specific provisions of law. As it relates to collection of rent, tenant argues that the hearing examiner erred in his determination that the issue is not communal, and claims that all tenants in the building should receive the $7 reduction. Tenant also claims that the hearing examiner erred by determining that there was insufficient evidence to address any claims of excessive late fees. As it relates to roof access, tenant argues that the rooftop has always been accessible to tenants for recreational purposes and disputes that the roof space is for emergency purposes. As it relates to interior painting, it is unclear to staff exactly why tenant is appealing, as tenant prevailed on this issue, but tenant appears to request an imposition of a condition on landlord before painting can resume. As it relates to loss of light, tenant argues that the evidence submitted shows a substantial reduction of natural light entering the unit, and therefore the hearing examiner erred in his decision. Landlord appeals the decision, claiming it is clearly an error, not reasonably supported by the findings made or evidence in the record, and is contrary to specific provisions of law. As it relates to the rent drop box, landlord claims that the hearing examiner did not follow prior precedent. Landlord claims that this exact issue was addressed in a 2019 decision D4354, and the hearing examiner determined in that case that removing a rent drop box was not a substantial reduction of a housing service. As it relates to interior paint, landlord argues that while the hearing examiner acknowledged that tenant requests their work be continued until after the stay-at-home order was lifted, he still granted the rent reduction. Landlord argues that they were scheduled to complete the work prior to the hearing and would have if tenant did not make such a request. Staff has reviewed the appeal record and recommends affirming in part and reversing in part as follows. As it relates to the collection of rent, staff believes that there's substantial evidence supporting the hearing examiner's decision that the removal of the on-site drop box results in a substantial reduction of a housing service. There's no dispute in the record that landlord provided an on-site drop box as an option to pay rent. The hearing examiner analyzed a prior decision from 2015, D-4049, involving landlord, in which the hearing examiner determined that the removal of an on-site drop box resulted in a substantial reduction of a housing service. As it relates to the issue of excessive late fees, staff believes that there's substantial evidence supporting the hearing examiner's decision that there was insufficient evidence to make a ruling on the issue of late fees. Neither party offered the lease into evidence, and because this issue necessarily requires determining what terms are in the lease, it is not unreasonable for the hearing examiner to determine he cannot rule on the terms of the lease without it being submitted into evidence. As it relates to the issues of whether the rent drop box is a common area issue, staff believes that the record lacks substantial evidence supporting the hearing examiner's determination to reclassify the issue. The record shows that the Dropbox issue was applied for as a common area matter, and that the other tenants in the building did receive notice of the application and were provided an opportunity to opt out. Because there's no evidence in the record of specifically when the housing service was eliminated, nor is there any evidence in the record of which tenants were residing in their units before the removal of the service, a remand on this limited issue is necessary. Therefore, staff recommends that if the commission finds the record lacks substantial evidence on this issue, it order a limited remand to determine 1, the exact date the Dropbox was removed, and 2, a complete roll of residents existing at the time of the Dropbox removal. As it relates to roof access, staff believes that there is substantial evidence supporting the hearing examiner's determination. The evidence in the record shows that while tenants may have used the rooftop recreationally and for smoking, it was not provided nor advertised as an amenity by landlord. As it relates to the issue of interior painting, staff believes that the hearing examiner's decision is not supported by substantial evidence and that tenant engaged in an intentional act that prevented landlord from completing the maintenance. The evidence of record is clear that tenant and landlord agreed to perform all necessary painting prior to the hearing. However, days before the hearing, tenant requested that the work be performed after the stay-at-home orders are lifted. Landlord agreed to tenant's request. The record also shows that despite tenant's concerns of the pandemic, he still permitted a landlord representative to paint his second bedroom before the hearing. The evidence also shows that the landlord is willing and ready to complete all necessary painting before the hearing. Put another way, but for the tenant's request, the painting would have been performed. As relates to the issue of overgrown trees and natural light, staff believes that there's substantial evidence to support the hearing examiner's decision. Because this issue was previously determined with tenant and ruled on by this commission in D4357 and necessarily requires a comparison to an integration of that case. Similar to D4357, the photos and testimony submitted between the parties were conflicting and subject to interpretation. However, based upon the evidence, the hearing examiner determined that the trees do not illustrate the blocking of very much light, and the conditions do not significantly differ from that of D4357. Therefore, based upon the above, staff recommends adopting resolution RSC 21-594. You as the commission have the power to affirm, reverse, modify, or remand the appeal determination of the hearing examiner as you deem fit. The commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the commission to make sure there is substantial evidence that reasonably supports the hearing examiner's decision is credible and of solid value. If that evidence is found, then the decision must be upheld, even if there's also evidence that could support a different outcome. The commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. As it relates to questions of law, the commission applies an independent or de novo standard of review to the hearing examiner's conclusions of law. Thank you.
Thank you, Mr. Natalia. Before we continue, I'm going to ask the commissioners, please make sure that you are visible all the time during the appeal process. So if you need a short recess, just let me know. Okay. Thank you. And with that, commissioners, at this time, you can ask any questions regarding the report you heard to the legal counsel. Any questions? Commissioneraggio.
Yes, to legal counsel, it was mentioned in the record that rent checks that were placed in the drop-off box were apparently stolen, but we don't really have any proof of that, do we? Except it is mentioned in the record.
Correct. What we have is the landlord's testimony at the hearing, but in terms of any sort of physical evidence or pictures or letters or something like that, not to my, there's nothing like that to my knowledge.
Thank you.
Other questions, commissioners? All right, I have a long question at this time. This is regarding the rooftop or roof access. In the report, I'm reading that. Well, obviously, your staff is supporting the examiner's findings, but in the report that you say that it was not advertised or it was not an amenity provided by the landlord as a for the recreational purposes, and I think it says that tenant claims that there was a table chairs, but however during the hearing stated he did not know place those items there. But when I'm reading the summary of evidence, it says that according to Mr. Horn, who would go onto the roof a few times a week, a former resident manager added a chair and table to there. So I wanted to clarify on that, if you have any information or if we can just.
So I guess if I understand your question correctly, you're asking if there's a disparity in the evidence. Yeah, because that will give me a completely different idea on whether this is a landlord provided housing service or not. If the resident manager who represents the landlord is a landlord's agent, puts their chair and the table and allows a tenant to go there and spend time, that definitely is a service provided by the landlord. So I think in that case, the examiner's conclusion that it's not a housing service, I would disagree with that. So I just wanted to bring this up and see if, but we can move on to the discussion, and you can just look into that and you can come back to that. At least to answer your question, I mean, the testimony during the hearing was that the tenant did not know who put the chairs up, and he said he suspected that it was the resident manager, and that was his testimony.
Okay. All right. It just caught my attention, but we can talk about this later. All right. All right. So this is an oral argument portion now, and this is a time to hear the parties. And as I said, the appeal was first filed by the landlord, So I would allow the landlord to go first. Sir, please, as you already been here, you know that you have to state your name and the city of residence, and you will have 5 minutes to address the commission. How would you like to divide the time if you wish to?
I think, hi there. I think 3 minutes now and 2 minutes later, please.
Okay, noted, Mr. Secretary. 3 minutes now and 2 minutes for the rebuttal. You may begin.
Thank you. And thanks everyone for joining us tonight, for giving us an opportunity to explain our views on this. Right now, I'm just going to talk about the rent drop box. I think at some point, we have a number of arguments. The first one is it's not a substantial housing service, the rent drop box. I think we have to use a little common sense. It's not that hard to put a check in an envelope and put it in a mailbox compared to putting a check in an envelope and putting it in the rent drop box. The only difference is writing an address on the envelope and putting a stamp on it. That's literally it. Now, is it harder? Yes. Substantially harder? No. It's probably 2% harder to do that. So, you know, while we did take the rent drop box down, we don't think it's a substantial disservice to the tenant. The other thing is administrative precedent. As was spoken about a few minutes ago, in 2019, in case D4354, I'm not just alleging the facts are the same. In this case, they are the exact same facts. And not only did the former hearing examiner rule in our favor that removing the rent drop box was a substantial reduction in housing service, the commission held that ruling too in 2019. You know, had the commission and the hearing examiner ruled against us in 2019 on this exact same case, we would have taken the rent drop boxes down at all. I mean, we would have left the rent drop boxes up, at the property in question now. But since we had a ruling back then and a ruling now that's different, you know, it's a disadvantage to the landlords. You know, there's a totally opposite decision with the same facts, and now we have a risk of a rent reduction. And this case has already been resolved at some point in the past, you know, back in 2019. And on the evidence wise, is there enough evidence to support the ruling? I would say no. Where's the evidence that it's substantially harder to place an envelope in a mailbox versus an unsecured rent drop box? There's no evidence in the record that says that's substantially harder. The evidence says the rent drop box was taken down, which we already know, but putting in a mailbox versus a rent drop box, it's not that much harder. And again, the other hearing examiner set the precedent. We think it's pretty clear on the rent drop box issue. And I can stop my time now, please.
Okay, so if that concludes your comments, we reserve your time for the rebuttal, sir. Let me ask if the commissioners have questions for the landlord at this time. Commissioner Copeland.
Hi, yes, I noticed in the letter that you sent to the tenants about the upcoming removal of the Dropbox. It also stated that Jamie Lee will no longer be able to accept any payments. Who was Jamie Lee? Was that a resident manager?
Yes, she was a manager before our current manager a few years ago.
Okay, so they would have been able to leave them with her or put them in the box prior to, according to the letter, prior to December 21st or whatever it was.
That would be pretty rare. Like we've done it before. We've done it with this tenant that we're talking about now. Where his check didn't come in, and we said, okay, give it to the manager this one time, and he gave it to our current manager, and we accepted it. We didn't make him mail another one in, but every now and then that might happen, even with or without the Dropbox. That might happen. Okay. You know, we work with people. You know.
Okay, thank you. Appreciate it. That's all I have.
Thank you, Commissioner. Other commissioners? I want to ask you, sir, regarding the rooftop. Yeah. At the hearing, you said that that the landlord has never installed anything on the roof and has never promoted it as an amenity. You mean the previous landlord?
Ever since we had the building, we've never done that. And we
So,
don't know
and-
that the former landlord did that ever.
So you became the owner in 2016, correct?
Yes, I believe so.
And the tenant, when did the tenant move in? To these
I think 2011-ish, 2010 maybe,
So
off the top of my head.
few years before you took over the property, okay?
Yes.
And well, that statement is very kind of a, it's a concrete statement. Did you talk to the previous owner to inquire about that? How would you know if that was not part of the deal when the tenant rented?
Yeah, I'm just saying that we've never done it, and I'm not aware of the prior landlord doing it. Now,
Okay.
I will say that every now and then, because it's on the roof, it's a small little area on two different roofs on the building. Every now and then someone will put a chair up there or put a little trash can for their cigarettes. And, we'll have to find out who it is and ask them to remove it. But, people want to put stuff up there, and we get it, but it's really just for emergency use.
But you only a year and a half ago, you said that, your tenants cannot use it for these purposes, right? When you purchased in 2016 up until a year and a half ago, all these years, you didn't have really big issue with that.
No, we did. I think the most recent thing you're referring to is when we put alarms on the doors. But even before we alarmed the door, it was never allowed. And if we did find out somebody was doing it, we would talk to them.
Okay. All right, thank you. Commissioner Ayers, you have a question, I believe.
Yeah, so Mr. Short, just on the same topic of access to the roof area, was there a safety concern on the part of building management that, is the reason why it's only for emergency access? Or did you have an insurance company tell building management that you shouldn't have tenants up there? What is the reasoning behind that?
Yeah, we've heard that from an insurance guy before, but the main thing to us is that it's a small area, and there's it's sort of enclosed by a short little wall, maybe 2 or 3 feet tall. And people have been known, because it's so easy to just climb over the wall, chill on the roof, on a pitched roof. It's not it's not a flat roof. It's flat on that little landing, but when you step over it onto the roof, it's pitched. So it's not super safe. It's not safe at all, really, for anybody to be up there. That's why we have to enforce it, and that's why we alarmed it. Otherwise, if you just kind of turn a blind eye to it, you get more and more people up there. Eventually, a cigarette causes a fire, or somebody gets on the roof and falls, and then who's in trouble? Us. So it's a difficult tightrope to walk, but we try to do the best we can.
Thank you.
Thank you, Commissioner. Other questions? All right, if we don't have more questions, I will invite the tenant at this time. And Mr. Short, you can come back with your rebuttal with the remaining minutes, of course. Mr. Horn, this is your time to speak, and you may divide your time also, your 5 minutes. Let me know how you would like to proceed.
I guess 2 minutes, or as much as I use right now.
And whatever is remaining, you can use it for the rebuttal.
Yes, thank you.
All right, just state for the record your name and the city of residence. Sure.
William or Bill Horn out, and I live in West Hollywood.
Thank you. You may begin now.
Okay, just regarding what Mr. Schwartz said on behalf of Christina Development, it's more than just dropping mail, a piece of envelope in the mail, it's the cost of it. Also, they are demanding it arrive by the 1st. They're not saying postmarked. That means the funds have to be available up to like a week before, as opposed to being picked up on site. Mr. Short also commented out there's an unsecured box. If it's unsecured, that's something that maybe they should worry about. There are also other things that he just said that are results of this, including mean notices on the door and the late fees that I have mentioned, which I've lived here for over a decade, Never until this policy started did I ever have a single late fee. Regarding the rooftops that have been mentioned, they're not for emergency, as Mr. Schwartz has suggested. They never have been. And yes, the manager that put the chair and tables up there, which I stated was their employee. And according to the standard of review, statements of fact should be left to the examiner, and that's what he decided. Moving on, there's a few things that really upset me about the whole process. My landlord was allowed to submit 3 to 5 times the amount of evidence I was allowed to. They were allowed to submit videos, I was not. I was not allowed to submit any evidence the Friday before the Monday hearing. That morning, my landlord submitted 30 pieces, more than the total amount I was allowed. Also in the hearing examiner, he says the roof was not an issue, he writes. It actually was. Page 61 of the packet will show you so. The city limits the scope of the plants about just sunlight. That's not my intent, and it wasn't the case. On page 58 and 66 of the packet, you will see the original process, it was bigger scope. 36 and 37, you see the appeal is bigger in scope. That was also something the hearing examiner decided at the meeting, and his decisions of fact are supposed to hold. The issue that I prevented the painting from being done, it was not 6 days, it was 3 days. I put my health at value and prevented 1 day. I don't know why the report doesn't mention the first day, their worker started screaming at me, yelling at me, got very aggressive, stormed out and refused to work. I prevented 1 day for my health, and at that point, not even 1/2 of one room was done. There are also other things. The examiner wrote there are 2 trees, there are actually 5 there. Another issue is the city was involved with the hearing examiner's decision, and that's not right. It's actually initialed by Celeste Farino, an employee. And I will leave it there for now.
All right, thank you. Whatever time you have remaining, you will be able to use it after the landlord speaks, all right? And Mr. Short, I would like to invite you back. And Mr. Secretary, can you please confirm how many minutes we have reserved for the landlord?
2 minutes and 28 seconds.
Perfect, 2 minutes and 28 seconds, so you can begin.
Okay, I don't even think I'm going to use all of that. I think I'll just address the roof and the rent drop box again. For the roof, I would just say, who is in a better position to say what the roof is for? The owner or the tenant? It's clear that the tenant loves the roof, considers it himself as an amenity, but it's just not. And I think I've explained why. I see why people would love to go up there, but it's not built for that. It's not safe. And again, we would know what the roof was for. If it was a big, large deck on top of the roof, you could argue it's amenity, but it's super tiny. And going back to the rent drop box, I will just sort of emphasize again, if decisions made in 2019 are reversed in 2021, that is not very fair to the landlord. Because when we get a decision that goes through the entire process, hearing examiner, staff report, commission, we sort of rely on that. We rely on that for our future plans. And again, had the commission ruled against us in 2019, we would have taken a different approach. We didn't. We took an approach based upon the 2019 ruling, and now in 2021, we have another ruling. So I would just say, again, there's no evidence to say it's substantially harder to use a mailbox as opposed to a rent drop box. I think it's clear it's not substantially harder. And that's really all I got.
All right, if that completes your comment, sir, then
Yes, sir.
I'll see if we have any questions, and I see Vice Chair Kirkis wants to ask you a question.
Yes, thank you. Mr. Short, you mentioned that it was problematic in the past when residents would go up on the roof, you'd talk to them. Were there any attempts, this was all prior to you putting the alarm on the door, right? The management putting the alarm on the upstairs door?
Yeah, some of this happened prior to that, and then we still have people that open the door and do it anyway, every now and then. But it's a little less now than it was.
And did you present to the hearing examiner any evidence of disciplinary or notes, emails telling tenants not to go up there? The ones you did
No.
catch?
No, we didn't. We just use verbal. Most of the time it's just verbal, and that's because people tend to work with us.
Mhm.
We tend to not have to like write a big letter saying, hey, you know. But, you know, yeah, I think it's plausible that people are going to go up there, and then we have to do our job and say, hey, please don't.
And you put the, when did the alarm go installed?
I believe in mid 2019 or late 2019.
Okay.
I'm not real sure off the top of my head.
2019 for sure though, right?
I think so. It's definitely before pandemic. So yeah, I would say.
Oh, I have that.
Thank you, Vice Chair. Commissioners, do you have any questions? All right, I've seen none. All right, thank you, Mr. Short. Thank you for being here and presenting your side of the story. Appreciate that. Vice Chair, is that question? No.
It is a question, but it's a question for, I can wait a little longer. It's for legal counsel.
Okay. All right, so then thank you, and I'll invite Mr. Horn. Vice Chair, I didn't catch what you said. The question to, not to the parties, right? Okay.
Yeah, we can wait. We can wait. Sorry.
All right. Okay. So I'll invite back Mr. Horn, and you have Mr. Secretary. Can you confirm the how many minutes we have left for the tenant to speak? Maybe a connection problem. Mr. Secretary, can you hear us?
Uh-oh.
Okay. I don't know what's.
Any questions for me in the meantime?
No, we can't do that now. So let me see maybe we can take a short break. Mr. Secretary, can you hear us? Probably not. Probably it's time to reconnect. Let's take a 3-minute recess and come back. All right? Okay.
I don't see our secretary.
He's having significant technical difficulties, but I did reach him by phone, and I have the time left for the tenant. So if the commission wants to proceed, I can handle that time commitment.
Sure, thank you. So the commission's back at about 8:09 p.m. And yes, and I'd like to invite the tenant to take the remaining, I believe, 2 minutes, 23 seconds. Yes, I believe so.
That's correct.
All right. Thank you, Mr. Manager. So, Mr. Horn, you have 2 minutes, 23 seconds for your rebuttal.
Okay, just back to the roof issue for a quick second. Landlord says they're the best position to know what it's for. They'd also be in the best position to provide evidence of what it's for, and I provided none. That's what it's always used for. Regarding the trees in front of my unit, the city keeps on trying to limit it to such a narrow part, but it's not what it's supposed to be limited to. I also discussed vines growing in my AC unit, how unkempt the bushes are, and the hearing examiner actually said in his report, landscaping is not a noted service, and it's actually a line item in city documents. Landscaping is. He chose not to discuss it and just flat out said it's not a service, which needs to be looked at. It is a service. On top of the fact I moved into a unit that had 0 trees in front of it. There are now 5. When they were first planted, they didn't even reach the top of my window. Now they reached over the 2nd story. There will be a point where my unit has no more light in it. It's going to happen. I mean, everything I predicted last time is come true. On top of that, again, the city was very involved with the hearing examiner's decision. Also, the city says I am to blame for the painting not happening, which is not true. I prevented 1 day, it wouldn't have been finished. And if that's the case, city law says all cases must be fully adjudicated in 115 days. Right now, we're at 279. That is not fair to a tenant who's waiting to have this adjudicated and made right. It's 279 as of today. It is required to be done with 115. That's not fair to the tenant. My landlord is a business. They're for profit. All the cost of doing business. It shouldn't lay on the tenant's shoulders for that burden. I raised this issue because my landlord did not reply to me whatsoever for months and months. I had to file a hearing. Now we're at close to 300 days. The hearing examiner himself was supposed to have a decision within 30. It took 90. That cannot be blamed on COVID. He had to sit home alone and write a decision. That's not fair to the tenants to sit and wait. Once the trees are an issue, the light prevention from my unit is an issue. Collecting rent is a huge issue. And even though the landlord says there was a case law, my agreement takes precedent over case law. And I haven't signed any document that changes my agreement. And that's the same thing about how my late fees should be wiped off too. I don't owe late fees. If he had a document signed by me saying I did, he would have presented it.
That's time.
He hasn't.
All right, thank you, Mr. Horn. Thank you for your time and
Do I get any questions?
comments. We're gonna just hold on a second, hold on, okay? Let me ask if commissioners have any questions for the tenant. Commissioners, you don't have any questions. All right, we don't have any questions to you, sir. And with that, I will close the oral argument portion of the appeal tonight. So the commission at this time may discuss, and I may ask questions to the legal counsel if you have any. And then after that, we'll begin the deliberation. I know Vice Chair would like to ask some questions.
Yeah, I just had a question for legal counsel about tonight there was reference, I believe it was the 4th, no, that wasn't it. Mr. Short has been referencing a decision that was the
4354.
I believe it ended with a, is that the one you were referring to, Mr. Short? Okay. I just was curious to know whether if you knew if this had been, if that decision had been appealed.
I believe that decision was appealed to the commission. 4354 was, I believe.
On the specific point of the mailbox?
As to the specifics of the appeal, I can't say. I know the staff report I included in the packet. The staff report for 4354 is in the appeal packet. But as to the specifics of the appeal and what the commission discussed, I did not watch that video.
I just want to confirm again, Mr. Short, you can just do this with nodding your head. The appeal or the hearing that the staff attorney and I have been discussing, that is the one that you're referencing in terms of the mailbox, where a prior decision was made that there was no value or no rent deduction. You can just nod your head or yes or no. Okay, thank you.
Thank you. Commissioners, other questions? Mr. Natalizio, I want to just, for the record, I think, well, I just want to correct what I said. Your report actually correctly represents what the hearing examiner summary of analysis says. So there was no discrepancy in your report. I just read it over again and just wanted to say it for the record. All right, thank you for that, and I apologize for the confusion. If no more questions for the legal counsel, we may begin our deliberation. Commissioners, who wants to begin? I can start. I can begin with the issue that bothers me today is that rooftop access, and I can explain my position on this issue. So I'm not disputing that this rooftop, this area, could be for emergency area. I haven't been to the property. I don't know what it looks like. The rooftop and the landlord describe it, and I don't have a reason not to trust what he says. But the question, the whole thing is not that. So the whole philosophy is whether or not this rooftop access was provided to the tenant for recreational purposes. So that is the whole philosophy behind the rent reduction issue. So if the tenant was permitted by the previous ownership, that could be the manager, the resident manager who acts as a landlord's agent, put the chairs over there at a table and it says, you guys can go there and hang out and you can smoke, you can just chat, you can have a coffee. So that is the service that the landlord, that's what we say, the landlord provided service because the manager allowed the access. So now the tenant doesn't have any idea, I'm speaking about the hypothetical tenant, not this particular tenant. Hypothetically speaking, a tenant may not have any idea if this area is for emergency access only. The tenant says, well, this is wonderful. So I can go upstairs and have coffee and smoke and chat, whatever. That's a service. And one day the landlord says, oh, you cannot do that anymore. So that constitutes a reduction of services under the our ordinance, because the bottom line is this was a service provided to the tenant and then it was taken away. It's not the tenant's responsibility to verify, to confirm if this is a dangerous, it is dangerous to be there, or if it's an emergency access only. So that's not the tenant's responsibility. That's the landlord's responsibility. And if the landlord, in a responsible manner, says, "Guys, you cannot go there because an accident may happen. This is an emergency use only, so this is not the proper area." Fine, the landlord has a right to do so, and the landlord probably should do so. But that should be a reduction in services, because again, it doesn't matter what is the reason why the landlord is taking it away. The whole purpose is, the whole thing is that this is the service that tenant was provided. Without his or her knowledge, whether it's dangerous, whether it's emergency access, et cetera, et cetera. So that's why that part bothers me. So when I'm reading the examiner's a summary of evidence, where the examiner describes that Mr. Horn testified that the former resident manager added a chair and a table, so which basically the former resident manager allowed the access to use for recreational purposes. So and then Mr. Horn takes over in 2016 and he says, oh no, the previous landlord never allowed that. But how Mr. Horn would have known what happened 6 years before that, because the tenant moved in 2010. There is no written record. There is no lease agreement. There is no letter from the previous owner to the new owner or the previous owner to the tenant saying, hey, don't use this anymore. So, so how would the new owner know what happened 6 years ago? So I would say if I was the examiner, I would more give a credibility to the tenant's testimony saying that, hey, he was there before, so he knows probably better than the landlord does, unless there is a written record from the previous owner saying you cannot go there upstairs, you cannot go to the roof area. That's one problem that I'm having with this rooftop, and I wanted to also mention that, yeah, I have no problem with the landlord removing it from the tenant's use. I have no issue with that. So, and they should probably be discouraged from going there, or even prohibited from using that area. There's no question about it. But that should become a reduction in services. That's my approach, my position, because under the rent control, under the rent stabilization ordinance, there is no requirement to put things in writing when you're renting a unit. There is no requirement to provide a service in writing, just like a parking space. A landlord may negotiate a parking service at the time of renting, saying, hey, you're paying me $1,000 and you can use parking A, but we're not going to write any agreement. That's a service that was provided at the time of renting. And that was negotiated at the time of renting. So that is the approach for parking service, and that is approach for any other service, and that should be approach for this rooftop service. So on the other issues, I'm pretty much in agreement with what staff recommends. But I can, I can come back after I hear your position, your statements, commissioners. Okay, so do you want, I can go in alphabetical order. Ms. Copeland, Commissioner Copeland, I'm sorry.
Hi, with regard to the rent Dropbox, despite the fact that there may have been a different ruling with similar evidence by a different examiner, I agree with staff that there is enough evidence to affirm the hearing examiner's finding that this was a removal was a loss of a housing service. The ability to give your rent to the resident manager or to drop it in a box as opposed to going to the post office, buying stamp, certified mail, whatever. It is a removal of service and a change in terms. However, I also agree to reverse the hearing examiner's decision that this was not a communal service, because whether it's a drop box for your rent or a dog park or a laundry room, it's a service. It's irrelevant which tenants use it, how much of the time, part of the time, none of the time. If it's available for those tenants to use and then it's removed, then I agree we need to do a remand to confirm the date the service was removed and which tenants that would have affected on that one. And I'll let the other commissioners weigh in on some things before I come back to another issue later. Thank you.
Thank you. Commissioner Ayers?
I agree with Commissioner Copeland on the Dropbox. her assessment of that for the reasons she gave. And plus, you know, even though in 2019, the hearing examiner ruled differently about whether it was a significant service, but I think it is a significant service, and part of the reason is the perceptions about what the post office service is capable of has changed since 2019. I think there is a public perception that the post office isn't as reliable as it once was. There hasn't been evidence of that turning around yet. And though I hope it does. And so even though a determination was made a couple years ago that, you know, that it's not a significant service because, you know, they could just easily drop it in the mailbox and rely on the postal service to deliver in a timely manner. I don't think that's entirely true anymore. And in what Commissioner Copeland said about just the Dropbox being there just in case, you know, so even if residents or tenants don't usually use it, they have that service there just in case they need it. And it was a service. So I agree with that determination as well. And I'll let it move on to the next commissioner.
Thank you. Commissioner Maggio?
Chair, sorry, do you mind if I just jump in real quick?
Yes, please.
I just want to let the council know that there's the dispute here is that the hearing examiner relied on a different opinion than what the landlord is arguing the hearing examiner should have relied on. And so the hearing examiner relied on an opinion D4049 that was also provided in the appeal packet. And so essentially the dispute is we have two cases where in D4049, a hearing examiner ruled that the elimination of a rent drop box was a substantial reduction in the housing service. But in the one that landlord is referencing, the hearing examiner determined that the elimination of a rent drop box was not a substantial reduction in the housing service. Unfortunately, in the 2019 case, the footnote that the hearing examiner left just says that the reason why she's ruling differently in 2019 than in 2015 is a difference in facts. Unfortunately, she doesn't set forth specifically what facts she's basing that differential on. But so the battle for the commission is going to be is that if you have two opinions by a hearing examiner, perceivably on the same subject matter where there's differing facts, is the reliance on one and not the other? Is that substantial evidence? And is believing that the second, or the other opinion not ruled on, the fact that the hearing examiner ruled differently, are you just substituting your judgment, or is there an actual legal issue between the cases? So I just wanted to let the council know that there's not just one case at issue, one hearing examiner's decision. There's a conflict of two.
So that's very important, sir, and I'm glad you clarified. So 2015 decision was that that is a substantial service Dropbox. In 2019 was a different decision. Okay, sure. All right, that's very important. I'm glad you clarified. I appreciate that. Thank you. Commissioner Ayers, you concluded your comments. Did I interrupt you? No. All right. So then, Commissioner Maggio.
Yes, in regard to the rent collection and the roof access, in my own opinion, is that I really think the landlord is protecting the tenants. It's already been said that the removal of the Dropbox is because there has been theft. They're stealing the rent checks from the box. So he's provided an alternative. It is true that since postage is 50 cents, that comes to $6 a year and an envelope. So I think that has to be considered. Is it a removal of a service? I think in some cases it is, but then we really have to determine who is it really affecting? How many of the tenants is it affecting? I would think that part should be remanded so we could find out that answer. As far as the roof is concerned, there again, I think the owner is protecting the tenants. It's not safe to go up to a pitch roof, even though there are small flat areas. It was not designed for that. I mean, there are codes as far as protection of railings. Do those railings exist? People smoking on the roof, I mean, I'm not even sure that could be safe either. That could be a fire hazard. So I'm not convinced that the roof is really a lost service. And then I'll continue. We'll just, you want to take this separately? Where we will discuss the interior paint and the landscaping last while we get through this, or shall I go into that?
It's up to you. So I believe that I have to go the second round because so far the commissioners spoke about the dropbox and the rooftop, and I want to give another opportunity for the commissioners to go next round and discuss other issues or bring up something else. So
right,
it's up to Commissioner Maggio.
I will then add those comments
Later on. Perfect, no problem. Commissioner Montemor.
I am in agreement with my colleagues who spoke earlier in regards to the mailbox. I do agree with staff's recommendation on reversing the hearing examiner's decision around the mailbox. I do believe it has affected all of its residents, and doesn't matter if they use it or not. It is a service that has been provided, and the landlord needs to recognize that, and there should be a reduction in rent. So in regards to the rooftop, since that was brought up, I'm not quite sure I do agree with that. I think on top of there being some safety and issues, I have not seen adequate evidence that it was a service that was supplied by the landlord to the tenant and all tenants on the property. So I'm not quite sure the commission has the ability or has the information and evidence to reverse the hearing examiner's decision on that. I will wait to comment on the other items as we do our second round.
Thank you. So then I guess I will make some additional comments, and I will go around because Vice Chair spoke. Or you want to speak now? Vice Chair.
Yeah, no, I haven't spoken yet, but I will.
Oh, okay. Yeah, you asked the question. Sorry about that.
Yeah.
Vice Chair, now you.
So on the first issue of the rent collection or rent box, I agree with what fellow commissioners have said, that although in my mind, I think it's a very small, it's smaller on the scale of services. It is a service, it is a convenience. All of the things that you define a service or I think enough has been said about that. The question, while I personally think that $7 is too much, that's not the question at hand. I'll press or I'll go with the hearing examiner's decision on that. Where the hearing examiner did err, and this is based upon, well, in my opinion, common sense and by precedent of this commission and several decisions in the past, many of them which I disagreed with because not everyone uses all communal services. I think this one is quite clear that it is a communal issue, and tenants that would disagree with that or don't feel that they should be have a rent reduction had the opportunity to remove themselves from this. So I would reverse the hearing examiner's decision on that. And then when we go to roof access, I think Chair Topkin explained it very well. I absolutely agree, and I've always, in cases, decided that even if it's a code violation, whatever reason it might be, the reason to me is irrelevant as to why a service was reduced or removed. And from 2010, I believe, is when the tenant moved in. We have testimony. The hearing examiner had testimony from the tenant that from 2010 to 2019, he was allowed to access the roof. The landlord testified that he purchased the building in 2016, and it was in 2019 when action was taken to prevent access to the roof. So to me, we've got quite a bit of evidence in that that was a service provided, in addition to the fact that a table and chair was placed up there. The only testimony that exists is that, although I don't put a whole lot of weight in that testimony from at least the portions of the previous hearing I had seen where the tenant was asked directly by the hearing examiner, do you know who put the chair and table there? And the answer was, no, I do not. But we heard that differently tonight, but in any case, there are other reasons why that should be overturned. Are we touching on the interior paint? I agree with the hearing examiner issue on hearing examiner on that issue, but I'm open to hearing from my other commissioners. The overgrown plants, before I comment, I'd like to hear what others have to say about that, because I don't fully remember our past conversations or our past hearings on this almost identical issue, except the fact that the reason that this is different than what we've ruled on in the past is that trees are probably larger now. And that's, I believe, based on my recollection in our previous hearing on this issue, that was one of the forecasts for what might occur, is that the reduction of light, we talked about vitamin E and all the other benefits of that, and the reason why the tenant originally chose that apartment. We discussed at the commission that someday that's the value of that that decrease in service could increase. So back then, if the decrease was $9, I'm just using that example, $9, then 5 years later, it might be $12. So I would like to hear what my fellow commissioners think on that issue. I think that's, I would agree that on the issue of the mailbox, we must remand it for the specific reason for the hearing examiner to determine who was tenant, who were tenants at the time prior to its removal. And I would say that the same is true for the roof. I would say that we should also remand it for that issue, that only tenants that were in the building prior to 2019 would qualify for a rent reduction there. I don't think staff had mentioned that in there, but if they did, I would recommend that we remand that issue if the commission agrees to overturn the hearing examiner on that as well. I think that covers most of my comments. Thank you.
Thank you, Vice Chair. So I'll make some additional comments on the items that I have not touched, and then we'll go at the second round, and after that we'll make a motion. On the first issue of the staff's recommendation, the Dropbox. Well, there is no doubt in my mind. Dropbox is a service. Dropbox is an amenity. If anything, this is what everybody needs to understand and remember. Anything that is provided at the time of renting the unit, anything that is a service or amenity or privilege, is a housing service provided by the landlord at the time, specifically at the time of renting. The landlord may add some stuff later on that will become a landlord provided housing service. Everything that landlord provides to the tenant, that is a housing service. Later on, taken away, that's a reduction of housing service. If it's a reduction of a housing service, a corresponding rent reduction must be provided. Otherwise, that effectuates an illegal rent increase. That is the mechanism here. And it doesn't matter what is the reason why the service is taken away. There could be a perfect reason for it or no reason for it. It doesn't really matter. The landlord can take anything away at any time, but the landlord must provide a rent decrease. So that's what the reduction of services is about. So therefore, the Dropbox is a service. Substantial reduction of services will occur if that service is taken away. Now, I was very surprised by the 2019 decision, but I thank you, Mr. Natalia, or legal counsel, for bringing up the 2015 case where that was determined as substantial service, because I was so confused. How is it possible that the examiner ruled differently? So now the 2019 circumstances or details of the case, of the fact pattern may be different than it was in 2015, or that is before us tonight. But we have the present, and I'm pretty sure years ago, if there were any Dropbox cases about the Dropbox, we ruled that these are the housing services. So therefore, I am in agreement with staff's recommendation on that issue. And also, I believe that we should reverse the issue regarding the application of that $7 monthly rent reduction to the other tenants, because it is a communal issue. If everybody was allowed to use that Dropbox, so that is a common service, that's a communal issue. And then the examiner should decide the dates, the moving dates for those tenants who will be determined to be eligible for that rent decrease. So I would agree on the reversing on that item. And I agree regarding the late fees. Late fees is a little bit different. If for some other things we can decide on the matter before us, even in absence of a lease agreement or rental agreement. But when we're talking about the late fees, and we're talking about the fees paid and the landlord collected and pocketed money, that we need some documentary evidence. So here we cannot really, I mean, the examiner could make the determination because of the absence of the lease agreement, I believe, right? And or other documentary evidence. So I agree with staff's recommendation to affirm the decision of the examiner on that matter. The next is again the rooftop, and thank you, Vice Chair, for also commenting and clarifying that. As I said, so it doesn't matter what's the reason why the landlord is taking away a service. It could be a perfectly reasonable, supported reason, a ground for taking away service. Yes, tenant safety. I agree that area should not be accessible by the tenant based on the landlord's description of the area. However, that was established as service. So even if it's above the tenant safety, the fact that tenant paid rent, and in that rent amount that the tenant paid was included that little service, going upstairs and having fun. So now it's no longer available, the rent should not remain the same. That is the whole logic behind this rent decrease issue. So now, yes, it is because of the safety issue, fire hazard, whatever hazard. But the fact that the tenant was provided that access, the service, now should be addressed here. So I believe the tenant is entitled to rent decrease. It should be determined as a housing service, and I would recommend, hopefully the commission will support that, remanding this item to the examiner for further discussion.
Chair, do you mind if I interrupt you again on this issue?
Oops. Oh, Mr. Natalia, you're back. Okay.
Sorry, it seems like on a number of issues tonight, there can potentially be
Something wrong with that.
a reversing of the hearing examiner's decision. And so I just at least want to just say, in terms of looking at the substantial evidence test, if we as the commission, you are going to reverse the hearing examiner's decision, for example, on this roof access issue, I just want to remind the council that in terms of substantial evidence, it's not a reweighing of the evidence or substitution of judgment. It's looking at the evidence that the hearing examiner relied upon and saying, is it reasonably sufficient and credible and solid to support his decision, even though there could be contrary evidence or evidence that could go the other way? Is there evidence in which the hearing examiner relied upon that is that's reasonably sufficient? And so I just wanted to make that comment.
So you're saying about the reversing. Can we remand this back to the examiner? Remand this item?
I mean, you could. The commission has the power to remand. I think that legally you want to use a remand not to reward or punish somebody who either didn't prove their case or didn't defend their case properly. I think a remand would be, applicable in a situation, like with the rent dropbox, where there just wasn't information relating to when this service was removed and who the tenants are, because that just wasn't information that was provided and the commission needs. This is just, in terms of legal opinion, my thoughts are the remand shouldn't be used to essentially retry something. Obviously the commission can disagree and do what they want, but that would be my thoughts about not using a remand to rehear, particularly if there is evidence in the record on it.
I see. Okay. Yeah, it's a good point, and thank you for clarifying that. I appreciate it. Vice Chair probably has a question for you.
Yeah, I have a question just to add some clarification, or could you clarify? So I see the decision of the hearing examiner in determining, basically it's one decision that determines whether it's a significant housing reduction and puts a price tag on it. I believe, is it appropriate to determine that the hearing examiner is just flat out wrong on not subscribing to the fact that removing access to the roof is not a housing service? I believe he's wrong to the core, but it may be a significant decrease in that it's only $3, or it's a significant increase in that it's valued at $100. That he would be also basing on the evidence in front of him, and that would be evidence. To me, it'd be more clear that that is evidence where he has weighed the evidence and determined that's the value. Whereas I don't believe that he is correct at all in determining that it has no value or is not a significant reduction. Is that an appropriate way of thinking for, or would that just not, is that circumventing what you're trying to say?
So I guess, and correct me if I'm wrong. So if I'm understanding correctly, is your question whether or not in this situation, the hearing examiner determined that the roof access was not a substantial reduction in housing service? Are you asking, can it be remanded, reversing the hearing examiner and then asking him to consider that what the actual cost should be in a rent reduction?
No, my question isn't about remanding. My question is it solid legal? If I were to argue that the hearing examiner is absolutely wrong in terms of it not being a significant housing reduction, not because necessarily that one side prevailed over the other in terms of arguing its value and whether it was substantial or not, but the hearing examiner's just flat out, refusal to accept the fact that we have on several occasions throughout the last 15 years said that a yard, all these other examples of balconies and things that were dangerous to the public, but were removed, and they still were a significant, basically, I think the commission has made it clear that based upon our past actions, that evidence of code violations may play into the value that it is reduced. Like an illegal parking spot has very little value, but a parking spot removed has a different value. But both to the tenant are a reduction in services. So my argument would be that blocking access to the roof comes with a reduction of services. Now, what that reduction is, the hearing examiner, based upon would determine what the value is. And in this case, since he determined there is no value, or he didn't have to place a value. So we can either choose the value or remand it. But my real question is about the issue of the two questions he's facing that are really all in one. So I'm not just replacing my own personal feelings or judgment. I think that he was wrong. I mean, I think that he just erred in his analysis of what is a significant reduction. I don't know if that.
No, I understand what you're saying, and I think that the legal issue right now for the commission to consider about this roof access was it a service that was actually provided by the landlord? And so I think that's the issue. And if the commission and the hearing examiner said it wasn't a service that was actually provided by the landlord, and so if the commission finds that it was a service that was actually provided by the landlord, they're free to do that. But I think that the commission should then deliberate upon what evidence is in the record that would support the commission's decision to essentially reverse the hearing examiner. And that was all I was trying to I guess say in my earlier interruption of the chairs. Essentially, if the commission is going to reverse the hearing examiner on this issue, then I was asked the commission have a deliberation upon what evidence they are relying that shows that it was a service actually provided by the landlord.
Anything else, Vice Chair? Nothing. Yeah, so, all right. So now I'm a little bit more confused, but let's hear from others. Because I thought we can remand, but the way that it's explained, it's better if the commission hears and decides, but we need to have a ground we need to justify the decision if we reverse it. But I want to just mention a couple of other things, and that's about and then I will, I will go another round for you guys to speak. So I just want to finish the list. Regarding the rooftop, it's still open. I disagree with the examiner's findings, as I explained. So the next is about the $50 monthly rent decrease for the paint. I would say that I agree with the staff recommendation to reverse the decision based on the analysis. And I believe the staff's recommendation is correct, unless I hear from fellow commissioners other arguments. I'm going to support at this point the number 5, reversing the examiner's decision on the $50 monthly rent decrease for the repainting. And loss of the natural light issue, I'm going to affirm the hearing examiner's decision on this matter, so I would agree with that. That basically concludes my comments, and I wanna ask you commissioners to just make additional comments to speak about something else. I know Commissioner Montemayor, you raised your hand, right?
Yes. Thank
Okay.
you. I think on the mailbox, it sounds like there is consensus from the commission on where we stand in regards to. I'll reserve I have a question in regards to the rooftop. In regards to all the other items, I'm in alignment with staff recommendations. I will just say as a comment, I was a little concerned to see that the lease wasn't put into the record. That would seem like a choice that should have been made that would have easily answered questions around the late fees, but that is my comment on that. In regards to the rooftop, I'd like our staff attorney just to review very quickly, if possible, the evidence that is in the record right now on this item.
As it relates to the roof access?
Yes, the roof access and it being the service provided, a potential service provided to the tenants.
So at least from staff's reading of the hearing examiner's decision, in reviewing the appeal record, ultimately I can't tell you guys, what's the right evidence or wrong evidence, but my understanding is that the hearing examiner is basing his decision off of the fact that the landlord testified that there is, they don't provide access to the roof to tenants for the purpose of anything recreational. They never have. The landlord has testified that it's their understanding that this has never been a service provided by the landlord to the tenants, and that the reason why an emergency alarm and door had to be installed was because of the constant, or not constant, but the continued use of the roof against their policies. In terms of evidence submitted by the landlord written, I think it was asked, were there any complaints submitted or correspondence or anything like that? I don't believe there was anything in the record supporting that. It was landlord's position that the chair and I think an ashtray and there was one in a table or something, landlord testified that they didn't put that up there. So that's landlord's position, and that's what's in the record for that. For the tenant, it's their position that this has been a service that's always been provided. When I reviewed the hearing, the testimony from the resident was they did not know who put the table and chair and ashtray up there. The tenant could have misspoken and is now saying that it was the property manager. That's up for the commission to evaluate in terms of credibility, but there's nothing written in the record that would show, that was submitted by tenant that would show the landlord advertised it, marketed it, told the residents that there was this roof access. The tenant also testified during the hearing that he was not aware of any sort of advertising or promotion by the landlord as to use of the roof access. I believe the one item that tenant did submit to support his position was a photograph from Instagram where he said it was a prior, or maybe it was the current property manager who took a photo of somebody on the roof and made a comment that was more social in nature than it was, saying tenants don't do this. And so he used that to show, look, the property manager is, up there for recreational purposes. My recollection of the hearing was that landlord disputed that and said he wasn't sure why property manager was up there taking photographs. Again, that's an issue for the commission to decide in terms of credibility about, that photograph. But to my knowledge, that's the evidence in the record on this.
Thank you. So I think it's probably fair to say that my perspective would be that we have two verbal arguments from both the tenant and from the landlord sticking to their points, but there is not, from my perspective, any substantial evidence at this time in front of this commission. So I'm not sure it meets the substantial evidence threshold. So I'm not prepared to reverse the hearing examiner's decision on this matter.
Thank you. Thank you, Commissioner. Okay, Vice Chair.
Yeah, just because I feel so strongly about this issue and this and other cases. I would agree with everything that the staff attorney listed off. That's my recollection as well through reading through the case. The only change I would say is that it wasn't that the landlord testified that they never allowed it. He was asked whether they ever promoted it, advertised it, stuff like that, and he clearly said no, and there's been no rebuttal of that. So I agree that that the landlord probably never wanted somebody on the roof. But the landlord, I mean, I look at also as evidences. We have two individuals testifying. One has been at the residence since 2010, claims that this is all, I mean, we have no reason to not believe him, that this has not been allowed all this time. New people buy the building in 2016, 6 years after the tenant has moved in. And it's only from 2016 to 2019, after the tenant testified that he spends 2 to 3 days a week up there. There's been no evidence provided that he's ever received a warning or told to get off the roof. In fact, there's been no even verbal evidence that the landlord has even spoken to this particular tenant about it. There's also the fact that there's a table that was up there for a period of more than 24 hours or a period of more than a week. The landlord has no obligation to preserve people's property up there, but by failing to act, they essentially welcomed or continued, I won't say welcome, that's a strong word, continued to allow, did not stop, did not barricade access to the roof until 2019. So, I mean, all of those are pieces of the bigger picture, and I would say evidence that shows that something was allowed, something was no longer allowed, and I believe it was a significant reduction in housing service.
Thank you, Vice Chair. All right, I'll go another round. Commissioner Copeland.
Hi, I'm just trying to digest all these comments about the rooftop. Meanwhile, I agree that there was insufficient evidence to address the issue of the late fees, of course. There was no lease presented, no receipts of any kind presented. So I agree with the hearing examiner's determination on insufficient evidence on that. On the painting, there's no question. I think there's an agreement that the painting needed to be done. And I understand staff's statement that the landlord should not be punished for agreeing to postpone this. What's problematic to me is that it took 6 months from the request to do the painting, and it was only scheduled for a few days before the hearing. And then, of course, this happened with the pandemic, another stay-at-home order. So I would definitely, at the least, with regard to the painting, be in favor of waiving that 6-month filing waiting period if the tenant would like to refile if that painting is not done. So that neither of them are punished for this this delay. With regard to the lighting, Vice Chair brought up some good points. There doesn't appear to be a significant difference from the last time in the photos. Whether this will change down the road as it grows longer, I I don't know. So that's something that might again be addressed later, but I don't have a strong, I didn't see anything that really was very strong to me to see that there was a substantial reduction, since the last time. So as far as the roof, this is a tricky one, as there's no question that maybe for a safety issue, it's not a good idea. But there's also no question that, as Vice Chair pointed out, this was something that was allowed for many years, and then it's removed. It's not allowed. So that leaves us with the question of, was the hearing examiner did not interpret the law correctly, that this was a reduction or a removal of a service. And I think that's the only thing we can determine on that issue. So I'd still like to hear what my other fellow commissioners have to say on that one.
Yeah, so next will be Commissioner Ayers.
Yeah, on the rooftop issue, yeah, I'm also conflicted about that, because I do believe that in the changing of hands with the ownership of the building, there was a change of service. There was a reduction of service by removing access to that roof area. However, I believe that the new owner's decision to restrict access to the area is probably a good one. And I hate the idea of penalizing a landlord for doing something that is probably right, that's probably needed to be done. But I think that we could possibly make a determination that there was a reduction of services, but say that service was valued at $1, as to not strongly penalize the landlord, but also stay consistent with the ordinance. And as far as the other items on this, I'm pretty much in agreement with what's already been said before.
Thank you. Let me, Vice Chair, let me allow Commissioner Major to speak, and then you will speak next, and we'll see what we're going to do. Commissioner Major.
I affirm the hearing examiner's determination that the removal of a drop-off box was a substantial reduction of a housing service, and affirm the corresponding $7 monthly rent decrease. However, reverse the hearing examiner's determination that the removal of the on-site drop box is not a communal issue. So we need to find out how many tenants that has affected. I do affirm the hearing examiner's determination that there was insufficient evidence to address the issue of excessive late fees. Also affirm the hearing examiner's determination that landlord's removal of recreational access to the rooftop was not a substantial reduction in a housing service. I want to reverse the hearing examiner's determination that the tenant's intentional acts did not prevent the landlord from accomplishing repainting of the unit and eliminate the $50 monthly rent decrease. I want to affirm the hearing examiner's determination that the unit loss of natural light resulting from the tree does not result in a substantial reduction of a housing service. Yes, it's quite obvious. You plant trees, the hope is that they grow taller, and that's what's happening. They're growing taller, and they will continue to grow taller. If they're at the second story, they're going to be at the roof line. Special note with these particular trees too, they're not the type of trees you basically can top. They have a very long, it's a palm stem and trunk, and I'm not sure if you cut them in half if they will continue to grow that way. So I'm going to hold firm to that. Thank you.
Thank you. Vice Chair.
Thank you. I just wanted to comment. I wanted to channel Allison Regan, our former staff attorney, in regards to the use of the word penalize. So nothing we are doing tonight is, in terms of rent reduction, is a penalty to anyone. As the chair has mentioned several times, that there's been no, the decision by the landlord to cut off access to the roof is not good or bad. It's irrelevant to us in terms of whether he should or should not have done it. It is his choice. It is his property. What we and what the rent stabilization ordinance sets out to do is that determines whether it's a significant reduction in service to the tenant, and then places a value on it. So no matter what the amount is tonight, and I know it's really difficult to try to separate the two. There's been cases in the past where there was like 40 units and there was a significant decrease in rent. In other cases that, when that total number comes out, it just does not sound fair at all. But our decision tonight is based upon what the decrease, if there was a decrease, and what the value of the decrease was to the tenant. So it's not, nobody's walking away from here tonight. The tenant or the landlord is the bad person for any actions that they took on that issue. Just wanted to clarify.
Thank you for clarifying that. So now it seems we have a consensus pretty much on every item, but not on the rooftop issue. So I want to ask if, well, it seems like it's the recommendation or the legal counsel's advice or explanation is for us to decide if we want to reverse the decision and maybe determine the amount of rent reduction here, which the commission, has done it in the past when we determine if it's a service and what will be the reduction for the reduced service. Since, as I understood that that's the direction that the legal counsel is kind of giving us. Is that how you understood that, or am I right, Mr. Natalia?
Right. So if
the direction is basically to reverse. If we disagree, the commission may reverse instead of remanding the rooftop issue.
Correct. I mean, the commission has that ability. If the commission ultimately reversed the hearing examiner and chose not to remand it for evaluation and wanted to do it themselves, then there would just have to be a discussion, following the evaluation guidelines about what would be the number that the commission would choose and the reasoning for it.
Okay, so if we do so, if we move that direction, can we take this item out of the staff's recommendation and vote on that separately, and have a separate vote on all other items, and vote on this thing separately? Because it seems like we have several commissioners going this way or the other way. I don't want that effect on the entire recommendation. So what's the legal proceeding?
So the cleanest way to do it would be going by the recommendation, the conclusion section in the staff report, which is page stamped 29, and going through each item
one by one
and voting on it. That's the cleanest way. If the commission believes everything but the roof access is not at issue, then you could make a motion, to do that. But the cleanest way to go item by item.
Item by item. So I like that. So that sounds much better. And for the rooftop issue, we can have a different motion to vote on that, right?
Correct. You don't have to follow the order. You could take it in the order you want. So each one would just be its own motion.
Okay, I think that sounds good, since we have kind of a different understanding on this thing.
I do want to
So-
say, Chair, the only thing is that ultimately it's going to depend on what the commission decides with the roof access. Currently, the resolution follows staff's recommendation. So ultimately, if the commission decides to disagree with staff, it would just have to be making that amendment to the resolution to make those changes. And then I would just have to, I'd bring it back at the next meeting for you guys to approve that resolution, because I'd have to make the findings.
Right, because we cannot vote on the resolution as it presented in your recommendation.
Ultimately, if the commission disagrees with staff.
If we disagree with that, got it. All right, so is that, okay, so we need to decide what we're gonna do, and I like the idea of voting on each item separately, but let me hear from Commissioner Copeland.
I just had a question about the paint issue. Do we need to, can we add in there about waiving the 6-month filing period? Can we add this to the resolution, or?
I believe
we
that's
have to
already
take
in the
it as-
resolution.
Can you repeat that?
I believe that's already in the resolution because that was part of staff's recommendation. I'll double check, but I believe it's already in the resolution.
Okay, thank you.
Thank you. All right, Commissioners, so I like the idea of voting separately on item by item. And if that is acceptable, let's go with the first item. The first item in the conclusion part of staff reports is affirming the hearing examiner's determination that the removal of the on-site dropbox was a substantial reduction of housing service, and affirming the corresponding $7 monthly rent decrease. We probably need to take a vote on this. And if Mr. Secretary, if you're available.
I'm sorry, do we need a second?
Oh, you're right. So, we need to make them, yes, Vice Chair.
Can we simply do like some of these are pretty easy. Like we can do just a voice. We don't have to go through the formal process, and then maybe at the end do the formal thing. I mean, even though we'll still talk about each one individually, is it all right if we just said I'll say yes on the number one and then move to the next one?
Okay, and then vote on the ones that we disagree if we have a different opinions. Okay, so let's do that. Okay, on number one, just indicate by saying aye if you agree with that.
Aye.
As it's presented.
Aye.
Aye.
Okay. All right. So number two. Then I will have to read it for the record. Number two. Reverse the hearing examiner's determination that the removal of the on-site drop box is not a communal issue, and impose a $7 monthly rent reduction to all applicable tenants, and order a remand hearing on the limited issues of number one, when exactly the housing service was removed, and number two, the moving dates of the current tenants to determine who is eligible for the rent decrease. Just signify by saying aye if you agree.
Aye.
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 None. I see none of opposing. Number three, affirm the hearing examiner's determination that there was insufficient evidence to address the issue of excessive late fees. All those in agreement say aye. Aye.
Aye.
Aye.
All right, no abstained, nobody's against, okay. The fourth item is affirming the hearing examiner's determination that landlord's removal of recreational access to the rooftop was not a substantial reduction in housing service. So now all those in agreement to say aye.
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 We have two commissioners, Commissioner Maggio,
I said aye.
Commissioner, okay, I think this is the one that we have to vote, right? So let me ask the secretary to come back and on this item 4, Well, then this is the motion. If it fails, we can make a different motion, or we need to make a different motion now, Vice Chair? Can you unmute yourself?
Sorry, that'd be helpful. I thought we were just going through informally right now, but this is the one we know we have disagreement on, so we'll come back to this one.
So maybe we'll come back later, because it's getting the, here and there. I know I cannot really see who's saying what.
I guess my point was, I thought we were going to go through each one and just say yes, no, yes, no. And if there was disagreement, then we'd come back to that one to discuss further.
Right, but I want to know how many people say yes or I'm in nay, because.
I accidentally said yes, but I meant no.
Okay, well, again, this number 4, we have ayes and we have nays, so we probably have to come back to take a vote on a different way, and I'm just going to move forward to the 5th one and come back to the 4th. That's what you're saying, Vice Chair?
We just talked about number 3, which is the commission affirms. I'm looking at the resolution when I say 3.
The 3 we did say aye for everybody. So number 4 is the rooftop, where we have different votes.
Sorry, my numbers are different. I'm looking at a different resolution, I guess. Sorry.
So
you're right.
I'm on page 29, the conclusion, right above the recommendation.
Okay.
Okay. So number 3, everybody say aye. You agree with that? Number 3, Vice Chair?
Sorry, I'm looking on the resolution. What page again are we on?
Let me do number 3 again. It's on page, actually it's on page 21 of the staff report.
29 is the page.
21 of staff report, 29 of the packet. And that's right above the recommendation, the last, very last part of the staff report. So I'm going to read it again. Affirm the hearing examiner's determination that there was insufficient evidence to address the issue of excessive late fees. That's the late fees issue that the staff recommends to affirm the findings. So just indicate if you agree with that by saying aye. Aye.
Aye.
Aye.
Okay, I don't hear nays. So the next, number 4, is the rooftop. So that the rooftop is, we have different votes here. Affirming the hearing examiner's determination that landlord's removal of recreation access to the rooftop was not a substantial reduction in housing service. So we have a couple of nays and we have a few ayes. So then we need to decide if we're voting separately. I recommend that we just take a vote on this one and then move forward on the rest. And see if this will be passed. If not, if we're not gonna affirm this the way it's written, then we're gonna come up with a different motion. Or we can make a motion now. Well, we have a motion. We have right now, we have this to affirm the hearing examiner's determination that landlord's removal of recreation access to the rooftop was not a substantial reduction in housing service. If somebody wants to second it?
I second it.
Okay, Richard Maggio seconded. So let's take a vote, Mr. Secretary, on this one.
Commissioner Copeland,
Nay.
Commissioner Ayers,
Nay.
Commissioner Maggio,
Aye.
Commissioner Montemayor,
Aye.
Vice Chair Kirby,
No.
Chair Topshin.
No. So it didn't pass, so which means we need to come up with the motion and to vote separately on this one. And I could make a motion, but the reverse to hearing examiner's determination, but that would require also to come up with the rent reduction, amount of the rent reduction on that. So I would say let's go forward No, we can't. We have to vote on this one first. So anyone wants to make a motion on number 4, Vice Chair?
This is the housing, or this is the
The
roof.
rooftop, yeah.
So I'm looking at the resolution that was provided by staff, and I'm just going to change a few words around. I'm going to move that the commission reverses the hearing examiner's determination. Landlord's removal of a recreational access to the rooftop was not a substantial reduction in a housing service. Number 1, the evidence in the record shows that tenants used the rooftop recreationally and for smoking. It was, and then I'm going to just remove that second part and I'll bring it up in the second one. And then number 2, tenant testified. I mean, we can combine some, just say, while landlord and tenant agreed that there has never been a promotion of the rooftop as an amenity. And so we can't say that because this is, I jumped to number 4, by the way.
Well, I think legal counsel needs to come back and just.
I guess we should ask what he needs, because I would just add to this.
Sorry, Vice Chair. So since it failed, number 4, now we are going to reverse the decision, and as you recommended that we need to explain and justify. So that's what we're trying to do, and probably we'll need your help.
To answer Vice Chair's inquiry, I just need you guys to deliberate, and then I can go back and watch the video, and I'll put in the findings based upon what you guys discuss, and then you guys can approve it. If at next meeting you want me to make changes, I can make them then live, so you can approve them at the.
Okay, I just wanted to know what's the process is like.
I move that then. I move that we reverse the hearing examiner's determination, the landlord's removal of a recreational access to the rooftop with not a substantial reduction in housing.
I think I think that sounds fine to me. But if we do that, then we should come up with the amount of a rent reduction now.
But we should first get a second and then discuss this.
Yeah. Okay. So
I'll second
Commissioner Harris seconded. And then we need to vote on that and then come back with the issue on the rent decrease amount. So Mr. Secretary would like to have a vote.
I think what legal counsel asked was that we discuss it further, to debate it, so that we have reasons, unless you can take.
Oh, we just had a discussion already.
Okay, unless that works.
I think I'm fine based upon what you guys have previously deliberated.
Sorry.
Okay. So, Mr. Secretary, we're ready.
Commissioner Copeland,
Yes.
Commissioner Ayers,
Aye.
Commissioner Maggio,
No.
Commissioner Montemayor,
No.
Vice Chair Kirby's,
Aye.
Chair Topshin.
Aye. Motion carries. Thank you. And let's finish this with the determination on the corresponding rent reduction for the loss of the service. Vice Chair, since you made the motion, do you have in mind any particular amount?
The staff or any of our fellow commissioners have access to
The guidelines?
That would be helpful, and I don't. Is our secretary by any chance?
I think I have what is.
I can pull them up if you don't have them. I can put them on the
I
screen.
have something that is, this one published 2019. Oh, you can't say anything. Where is that? Okay, right here. Oh, wow. So it's 2019, print July 1st, 2019. But go ahead, Mr. Manager, just, guide us through.
Okay, I'll share my screen.
Oh, you have it on the screen. Perfect.
Yeah, hold on just one sec. Can you see that?
Yes, that's what I have, and that's perfect. Thank you.
So I'm sure you're looking for something analogous.
Do we have outdoor patio or something like that, or a balcony or anything?
And those on our subcommittee should take note of what we're missing on this list.
It is actually something we're addressing. We've added it.
Yeah,
We did.
we've added quite a bit to the list, I think.
We did.
I can't believe we don't have patio or anything like that.
Here we go. Oh, no, that's sunshades.
There's pool, not to say that is equivalent, but it's.
Oh, here's a balcony, right? Oh no, sunshades on the balcony or something.
I know it's been a long evening, but I could do a quick search of our document database because I think balconies have come up before. So if you want to do a 5-minute recess, I could see if there's precedent.
That's a good idea.
Yeah, that'd be great.
Let's take a 5-minute recess and we'll reconvene in 5 minutes.
I think, Mr. Manager, I believe I don't know the address right offhand, but the apartment building that a former movie star, but entertainer lived in for a while, or theoretically lived in for a while. I believe that one had actually, Commissioner Copeland might know. Isn't there a balcony issue with one of those properties?
Actually, there was a termite rotted balcony that could not be accessed, but it was part of the unit, could not be used.
That's what I was thinking of it.
That was either $20 or $30 a month, Josh, right off the top of my head. Commissioner, Vice Chair, I can't at this point, but it was $20 or $30 a day. But it was an individual unit. It wasn't a common area, so that might have been a little higher since it was an individual unit.
Yeah, we need a common area thing.
Yeah, and in the meantime, Mr. Manager, can you also verify the current rent the tenant pays?
Sorry?
Can you also verify the current rent amount the tenant pays? If you have.
I'll defer to counsel if he has that. It should be on the staff.
Okay.
I don't have it in front of me. Okay, so are you going to?
Yeah, okay, so we'll take a recess for 5 minutes. We'll be back at 9:37, 9:38 p.m. Thank you. Okay, I call this meeting to order. It's 9:39 p.m. Can you hear me, guys? Okay. All right, now everybody's back to the meeting, and Mr. Hollop, were you able to find something?
I possibly found something that could be of value, particularly based on Commissioner Copeland's comments as well. Case D4005, it's a 2015 case in which a yard space was substantially modified and resulted in a reduction for the hearing examiner's decision. In that case, which keep in mind it was about 6 years ago, the valuation was $25. That's kind of the most analogous case I could find in a 5-minute search of 4,500 plus cases.
Yes, Vice Chair, please.
Was that the a case where it was a small side yard that was closed off because of access to, like, I don't know if it was like water, or there were things they didn't want the tenant around. It was like I don't want to say electrical. I think it was like gas and stuff like that. Is that the same case, or am I thinking of a different one?
I don't see anything about that. It's quite a lengthy case, so I didn't read the whole thing. But yeah, I don't know if it's the same case.
I'm sorry, was that a communal issue, or did that just affect one tenant, that particular case?
It was part of a duplex. So it appears that more than one tenant did use it at given times. Yeah.
Commissioner Maggio and then Commissioner Ayers.
Yes, I'm sorry, but I think it's unfair to come up arbitrarily with some number that there has been no study on whatsoever. I think it's unfair, and I don't think it's equitable. We want to come up with a number, then there has to be a study. You just can't pull a number and say, well, this is the amount. We haven't really studied it. I don't think it's right. And if the legal counsel wants to weigh in on that, I would appreciate it. There's nothing on record that talks about roofs. And to sit here and arbitrarily make a number up, I don't think is correct.
Yeah, I mean, I guess I can't tell the commission how to deliberate, but I do think that legally your position would be stronger if it was supported by precedent, and then the number was supported by, something other than we feel X. So in that sense, yes, I agree. Legally, it's stronger. The commission can ultimately do what they will. If the commission also wants to potentially continue this item to give staff time to review prior decisions, or if they want to remand and have the hearing examiner figure out evaluation, I think they can do that as well. So there's a few options.
I think it would be fair to remand it so that we could really come up with a number.
Okay, thank you, Ms. Natalia. But thank you, Commissioner Maggio. Let me go to Commissioner Ayers and then Vice Chair.
Actually, what Commissioner Maggio brings up actually supersedes what the comment I was going to bring up, because I was going to ask more questions about the case we're trying to base evaluation on. And I think that I agree. It would be best if staff had the time to actually research this, find something comparable, whether they bring it back to us or if it's a remand for the hearing examiner. I could go either way on that, but I do think it needs more research.
Thank you, Commissioner Ayers. Vice Chair?
I have absolutely no problem remanding it, but I would absolutely disagree that the direction we were heading was arbitrary.
Say what?
I said I would absolutely disagree that with the direction we were seeming to head was arbitrary by any means. We had just taken a recess to have staff do some research on past precedent. We hadn't even gone all the way around on comments for the justification for what we hadn't even chosen a starting point. So we do this as commissioners all the time when the commission chooses to do so. And so, but I have no problem sending it back to the remand it for this specific to the evaluation.
Okay.
I would be amenable.
Montemayor?
I would be amenable to having this remanded.
Okay, thank you. Well, I agree with.
One question. In addition to this, is the rent reduction to apply to all tenants who are impacted, or is it just to apply to this tenant?
So that would be as we deliberated. I believe that was mentioned somewhere in the deliberation that if it applies, since it's also a communal service, so that would be applicable to those tenants who've been affected. And the examiner has to determine again, the date of the tenancy that started and who will be eligible, just like in the dropbox situation.
Certainly. I hadn't heard that, so I wanted clarification.
Yeah, but it's a good question. I'm glad you asked. I agree with Vice Chair comment in regards. Yes, the Commission has the right to make a for the commissions, obviously, for the record. The Commission has a right to make that decision. It's not arbitrarily. It's the Commission. The Commission has a right to make the decision on the rent decrease matter, and we can decide the amount. But I completely agree with you, commissioners, and with the way that the legal counsel explained. It makes total sense, and it would definitely be a right thing to do to remand this particular item, which is the determination of the amount of rent for this tenant, and also if it would be determined as a communal, then there would be the examiner to determine if there would be other tenants eligible or not. So we're remanding the amount, the determination of the amount of a rent decrease to the commission, to the examiner. Yes, Vice Chair.
I would feel more comfortable if we didn't remand the decision of whether it's a communal thing or not. That's the commission should make clear that this is a communal issue, but the value of it and who qualifies for sure.
Right, that's what I meant. If I explained that way. So the decision on who will be eligible, which tenants will be eligible to get the rent decrease. There's no question that's a communal because it's a community area. So I think that's.
I agree with the Vice Chair. For the record, I think that just needs to be very clear that that's the direction, because I did not understand.
Oh, sorry about that. So yes, the direction would be to recommend that the hearing examiner determines the amount, the monthly value of the reduced service, which is the rooftop service, and if there are other eligible tenants and tenancies that would be applicable to receive the rent reduction. That would be a decision of the hearing examiner to make. Right, so that sounds better. Okay, so with that, we will. Do we need a vote on this, Mr. Natalia? We need to vote, right?
Well, there's nothing to vote
remand
on
this item.
Because I'm going to have to bring the resolution back for the next meeting. So at that meeting, the commission would then vote on essentially adopting that resolution or not. And if there need to be changes, again, I said I'll make them real time and you can adopt that. Because based upon your deliberation, I believe I understand the commission's position on each item. And so I'll be able to update the resolution to do that. And so the commission would just have to vote essentially to continue the hearing to the next meeting.
Okay, so that sounds good to me. That would be direction of, for the legal counsel to drop the resolution, and reversing the examiner's decision on the determination on that the landlord removal of recreation access to the rooftop was not substantial reduction in housing services, and that to determine the amount of rent reduction that would be applicable to all eligible tenants. And that would be in the resolution that will probably will be presented to us in the next meeting.
If you need a
Okay.
second on that, I second it.
Yes, Vice Chair.
I have a question, but I don't know. Do we need a second? I don't know. I have a question
Yeah,
about.
I believe we still need a second, and Commissioner Ayers seconded, so that's a direction for the legal counsel. So we're going to take a vote on that.
And then I have a question about, the tenants is already talked about, and fellow commissioners, some of the commissioners have mentioned about the length of time that is taken for this process. For those aspects that need to go back to the hearing examiner, could we at least make sure that they fall within regular standard timeline and not exceed the timeline any longer? I mean, I agree with the tenant who mentioned, I don't know why the hearing examiner would need more than 90 days to make a decision. It's the hearing examiner. So just, I don't want to extend this out longer for the tenant and the landlord than necessary.
Okay. All right, so then we have two items that are left from that we have to indicate here, yes or no. Item number 5, reverse the hearing examiner's determination that tenants' intentional acts did not prevent the landlord from accomplishing the repainting of the unit and eliminate the $50 monthly rent decrease. Please indicate by saying aye if you agree with reversing this item. Aye.
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 Any nays? No. Okay. The last one is number 6, to affirm the hearing examiner's determination that the unit's loss of natural light resulting from the trees does not result in a substantial reduction of a housing service. Again, if you're in agreement of affirming the hearing examiner's decision on this matter, please indicate by saying aye. Aye.
Aye.
Aye.
Anyone disagree, say no. See none, so that carries also. So we voted item by item on all we voted one by one on all items of this conclusion as the staff's legal counsel recommended, and we will have the resolution presented at the next hearing. So we're not going to vote on the resolution as included in our report tonight. So that concludes our appeal for tonight. All right, that was a long night. Now, thank you, everyone. If the parties are here, thank you for your patience and for your argument and for your presentation. So if you have any questions about what happened tonight, please make sure that you contact the staff during regular phone hours. And I always forget the phone number for the department. It's right here. The Rent Stabilization Housing Division, you can contact them at 323-848-6450. So if you have any questions about the appeal tonight and what happened tonight in the meeting. All right, we're moving on to the next item on the agenda, which is the new business item, finally. And that is And we have one topic for discussion, and that is the announcement of 2021-2022 annual general adjustment and relocation fees. The commission will receive the department report on this matter and will announce the annual general adjustment, AGA, amount effective September 1st, 2021, and the new relocation fee amount effective July 1st, 2021. This is to receive and file only. So with that said, Acting Rent Stabilization and Housing Manager, Mr. Hollop.
Good evening again, Commission. I'm going to share my screen and quickly go through my presentation. If I can share the screen. Okay. So tonight, as the chair mentioned, is the announcement of the annual general adjustment and the relocation fees for 2021-2022. Per West Hollywood Code, Section 1736020, the authorized percentage increase to rent stabilized rents shall be equal to 75% of the May to May percentage increase in the LA, Long Beach, Anaheim CPIU for all items, rounded to the nearest quarter of a percent. So without doing every mathematical calculation, we'll just go through the basics. The May 2020 CPI was the figure shown, 276.842. Last month's CPI for that category was 287.620. That's an increase of 10.778 points, or a 3.893 increase. 75% of that figure is 2.920. For the ordinance, it's rounded to the nearest 1/4%, which brings us to a 3.0 AGA for the 2021-2022 period, effective September 1st, 2021. So that's the announcement. But this year, the AGA cannot be applied until 60 days after the local emergency is lifted. So it is not allowed to be taken at this point. The local emergency is still in effect. But I will report back to the commission when that happens, when that ends, and then 60 days after that point is when the AGA can be taken. With respect to relocation fees, that's governed by 17.52020C of the code. Those fees for no fault evictions are increased annually by the percentage change in the rent of primary residence component of the CPU index for the area. May to May as well. Quick recap of those figures. The May 2020 CPI was 399.259. The May last month's was 402.87879. That's an increase of 3.62 points, or a 0.91 increase. And those were applied. And here are the updated relocation fees for 2021-2022. As you can see, it's governed by size of the unit, unless there's a qualified tenant, 62 years or older, disabled, dependent with a dependent minor child, terminally ill or of moderate income, or a lower income tenant. There's a higher relocation fee there. That is effective as of the 1st of next month. And that's my report. Available for any questions.
Thank you, Mr. Manager. Commissioners, Vice Chair, please.
So after the 60 days after the local emergency ends, so let's pretend that's in, let's say, January. Let's just say that for this question. Whereas in many years past, many landlords just automatically increase the rents every September 1st. Or I won't say most, but many of them do just when it comes out, they're on that cycle. So those who have to wait the 60 days and they increase it in January when it becomes available to increase, they would not be able to increase it in September. They'd have to wait till the following January to take next year's increase. Is that correct?
That's correct.
Thank you.
Mr. Hollop, how this information usually being published in the city?
We'll send it out. We do a biannual, well, it'll be on the website, of course. But around this time every year, July, in fact, we do one of our biannual rent stabilization mailers to both landlords and tenants of rent stabilized units. So this will be transmitted along with the information that it can't be taken until the local emergency ends.
It's also translated, available in Spanish and Russian?
Yes.
Okay, perfect. All right, so the action is required by the commission is basically just to announce it, and no vote is required, and it's just receive and file. So with that, we just, the commission announces that the annual general adjustment for the year of 2021 and 2022 will be 3%. And for the relocation fees, the the increase will be of 3.62 points or 0.91% increase for the year 2021. So the AGA increases effective September 1st, 2021. And relocation fees will be effective July 1st, 2021. Whereas the AGA increase cannot be collected until after 60 days is passed after the lifting the emergency order. So there is nothing else for us to, I guess, discuss. It's received and filed. All right, Mr. Manager, thank you for the report. Commissioners, are there any follow-up questions regarding this matter or any other issues to the manager? All right, okay. So then with that, we'll move on to the next item, which is the public comments. And I don't know if we have any speakers at this time.
We do.
Mr. Secretary.
Yes, I believe we have Aaron Casto is back.
Okay.
Re-admitting him now. The
All
number.
right. It's a new speaker. I'm sorry.
Yeah, I believe it's the speaker who tried to join us earlier.
Oh, right. Okay. So before we begin, for the record, I need to state that the Rent Stabilization Commission values our comments. However, pursuant to the Brown Act, the Commission cannot act on items not listed on the posted agenda. Members of the public have 3 minutes to speak. This public comment period is to address the Commission on agenda items or items of general interest within the jurisdiction of the Rent Stabilization Commission. With that said, please state your name and the city of residence for the record, and you will have 3 minutes to speak.
Hi, my name is Aaron Casu. I want to say good evening, dear members of the Rent Stabilization Commission. I've been a West Hollywood renting resident for over 12 years. I live at 1117 North Vista Street, and I want to thank you for your service to our colorful, diverse community. Jumping in, the Ellis Act for Tenants in Common, we are asking for more time for WeHo renters, especially rent-controlled units, asking 1 year standard before being forced out as opposed to 120 days. As we have been noticing a large increase in TICs newly on the market in WeHo. Giving this time to West Hollywood renters before forced evictions could provide more incentive for developers to pay out tenants at fair rates if they want them out sooner. For the relocation fees involved with Ellising, after speaking to other WeHo tenants who are also going through the process post-pandemic, it's easy to find that the current fees do not allow any kind of relocation within the city. I have a 2-bedroom and that I've taken care of, fixed up, and made 4 times better than I found it. I love buying flowers seasonally to add to our historic street. I love my city, but I won't be able to stay in the city longer than 4 months, accepting my allotted $14,000 to relocate from the Ellis. When a unit like mine, in much worse condition, goes for $3,395 per month up the street. Not to mention things are still unstable in the wake of the pandemic. So I'm acting on behalf of a few that weren't able to speak tonight, and we're deeply asking the commission to reconsider what is fair relocation fees or fees based on the market differential for longtime tenants facing the end of their abilities to house themselves in West Hollywood, thanks to out-of-town developers. So I want to thank the commission for your time, and thank you.
Thank you, sir. Thank you for speaking at this late hour, and we appreciate that you raised your concerns. Thank you.
My pleasure.
Mr. Secretary, we don't have other speakers as far as I understood.
Jillian Marcus has re-entered the waiting room. She already spoke during the first public comment period. I've emailed her and advised her to email me with any questions. If the chair would like to address her, I can readmit her, or I can let her remain in the waiting room and follow up with her after the meeting.
Regarding the issues that she discussed at the beginning,
I'm not sure.
we can't discuss anything with the speaker. If she would like to make additional comments, she may take her 3 minutes and speak before us, but we're not going to discuss any issues with her directly. You can ask her if she wants to just make a statement or a comment. She can do it. She can take her 3 minutes.
Hello, Ms. Marcus, can you hear us?
Looks like she's connecting. Mr. Chair, can we maybe move on and then let her speak if she's able to connect after we give our comments and stuff at the very end?
Okay, so that's a good idea. So let's move on to the commission comments. Next will be our comments. Commissioners at this time would like to begin. Commissioner Maggio, please.
Yes, I just wanted to make a mention of relocations. You know, if you're 62 or older and you've been Ellis, then you're allowed 1 year to vacate. And hopefully, this is, of course, this is a comment, but I hope that that could be applied to every tenant in an Ellis building, a 1 year actuality. Also, my last comment is I think we really have to do a moratorium on development. It's just going so fast, and these are very different times. And although that's not our decision, but it's a comment that I feel necessary to make in order to protect tenants. Thank you.
Thank you, Commissioner. Commissioner Ayers.
Yeah, I would love for our commission to take up the possibility of recommending to City Council that the city adopt a year for all tenants being Ellis, if that's something that's within our purview.
Thank you. Commissioner Copeland. If you have any comments.
I agree with what Commissioner Maggio's sentiments, as well as Commissioner Ayers. The 12-month noticing period for everyone is something that's come up before. Is that something Vice Chair Kirby's might know? Is this with our state electeds as far as the Ellis Act ruling, or is this a West Hollywood noticing period, the 120 versus the 12 months?
I believe it's everybody. I mean, it's a statewide Ellis Act.
State electeds, that's what I thought, yeah.
Thank you, Commissioner. Commissioner Montemayor.
I have no comments at this time.
No comments, okay. All right, thank you. Vice Chair, please.
No comments, thank you.
No comments.
I'll just thank staff on the report tonight and the way it was put together. That was a lot of information, but very well organized, so I appreciate that.
Thank you. I also want to make a brief comment. So in regards to that 1 year extension and 120-day notification, it's under Ellis Act. It's a state law, as Vice Chair also confirmed. The city cannot change it. it's not up to the city, obviously. So it's in the state law, unfortunately. So as for the, well, I will also want to comment on the report. I think it's an excellent report, and the staff's report for tonight's appeal is just incredibly well prepared and covered the way that it's easy to understand and go from item to item, and it's so much better this way. And I want to thank the legal counsel for taking so much time in preparing this. This is an absolutely incredible and excellent report. Thank you very much for that. So that makes our job a lot easier, obviously, when we're preparing. Also, I wanted to mention that on June 15th, I don't know if you commissioners had a chance to attend the virtual housing element workshop. Did you have a chance? Yeah, I think it was a nice workshop. Was well prepared. Obviously, I want to thank staff for putting together that workshop. There was some interesting data and presented very well. But I thought what's missing is that communication kind of a part. Yeah, it was nobody could see no one. There was no like a really engaging. Maybe it was designed that way, but I thought it was a little bit awkward. So I was sitting there and I'd only see these three, people who were presenting, and then nobody's there. And you click the chat room, you don't see any questions or anything. So there was no engaging in that way, although there were kind of a polling questions. I think 3 or 4 maybe. But I would say that because the when the pre-COVID era, when we had those gatherings and, a housing element meeting or general plan meeting was kind of a really good discussion, everything. I was missing that. And I thought maybe this virtual meeting will kind of have some sort of element of it. I didn't see it, but the whole thing was very interesting, very important. And I would definitely encourage, I think that's going to be another one soon. I don't remember the date, but I encourage everyone to attend if you haven't done that yet. So, and it's important to show that support, or not the support, to show the concerns and questions. And there were some good questions, and I tried to give my fair responses. And it was interesting when they gave the percentage who voted how. And I said, wow, I was sure that this question will be voted, like we'll get like a majority of people supporting this or that other item. So I think it was good. And I don't regret the time I spent, and it was only 1 hour though. So anyways, I want to thank that. I wanted to share with you. And also the city clerk sent the email today, I think before the meeting, informing that the city council on June 7th approved the revised bylaws for the city commissions and advisory boards. I just want to encourage everybody to read and review it. It was attached to the email. So that's, I think, that concludes my comments at this time. All right, thank you. With that, Mr. Secretary, do we have Ms. Marcus back? Oh, I'm sorry, Mr. Maggio, I missed you. That's why I'd like to see you all the time. So you have to be visible.
Yes, I want us to, I should have asked this earlier, but I hope everyone will agree if we could adjourn our meeting in honor of one of the most beloved residents of West Hollywood, Bernice Levin, who passed away today. She was so active in our senior movement and certainly with some senior cable programs. And she was a lovely lady who also was Ellis and had to move out of West Hollywood. But to her family, I extend my deepest sympathy, and I hope that we could adjourn in her honor. Bernice Levin, L-E-V-I-N, Mr. Secretary.
Thank you, Mr. Maggio, noted. Thank you. Mr. Secretary, do we have Ms. Marcus back?
Looks like she can't connect to audio. I'll follow up with her after the meeting.
Okay, so let's move on to the staff comments. And We have both the manager and the legal counsel.
Does it look like Ms. Marcus couldn't get on, and Roger's got her information, so staff will follow up with her. And just a reminder, staff can be reached at rsh@weho.org or 323-848-6450. That's all I have. Thank you.
Thank you, Ms. Manager. Mr. Natalia.
I just wanted to thank Chair and Vice Chair's comments about the staff report. At the City Attorney's Office, we work hard to make sure that you guys have everything you need to make sound legal decisions. And so I just want to thank the Commission for their, well thought, reasoned, and intense and good deliberation. It makes our jobs easier. So thank you to the Commission.
Thank you. Thank you very much.
Thank you.
All right. With that, that concludes our items for tonight's meeting, and I will adjourn this meeting in memory of West Hollywood resident Bernice Levin. And the next meeting will be held at 7 p.m. on Thursday, July 8th, 2021 via teleconference. Thank you, everyone, and good night.
Good night.
Good night.
Take care, everyone.
Jonathan, are you
Thank you.
strong? Do you know, and then Commissioner Copeland, you might be interested as well. Do you know if, when I commented earlier on the Ellis Act, I wasn't thinking specifically about tenants in common, so I don't know if the city has authority there for the transfer from the use of the property, because that's different than just, or maybe different, I should say, than just a regular use of the Ellis Act. So I don't know if the city could circumvent the Ellis Act by saying, if you want to do a tenant in common, you have to give any current tenants 1 year. I don't know if that's legal or not. And you don't have to answer. I'm just throwing that out there. I want to kind of correct myself because I said, no, you can't do that.
It's a good question because they are popping up. We've got one on my street that was converted to a tenants in common recently. So that's a good question. So I'm sure our acting manager has all the answers.
Just not tonight.
Yeah,
No.
sounds good. Thanks.
Have a good night.
Everyone.
Thank you. Good night, everyone. Thank you.